Prepare to begin, please. Eduardo. We are on our third and final day of the hearing in EIB 25-77. This was a petition proposing the repeal and replacement of 20.2.71 and 20.2.75 of the New Mexico Administrative Code relating to air quality permitting fees. We will finish the evidentiary record today, and the board may choose to go into deliberations following the closure of the record, but they have not yet made that decision. We have reached our third public comment session, and I have the names of a few folks who've indicated an interest in offering comment. Let me start in the room, though. Oh, Ms. Sona.
Thank you, Madam Hearing Officer. Ms. Jones, would you be able to share which of our members are on the platform this morning? Hard for me to see.
Yes, it's at this point, Member Bitzer is the only one that's on the platform.
And
Member Sweeney, or Vice Chair Sweeney, said that she would join us as well.
She's there now. Okay.
Yeah.
thank you very much.
Yeah. All right. Yes, Vice Chair Sweeney is juggling this hearing and speaking engagement later today. So let me go back to public comment. I will ask you to spell your first and last name. I'll ask you, pursuant to board rules, to swear or affirm that you will tell the truth. I'll ask you to keep your oral comment to about 3 minutes, although you may submit written public comment of any length. That needs to come in before we adjourn today. You would send it to Pamela Jones. So let me ask first if there's anyone in the room here. I'm sorry. Oh, thank you, David. Ms. Cardino, the hearing is being recorded and transcribed by David Lee of Cumbre Reporting. It is also being interpreted between Spanish and English and Spanish. A team of interpreters. Ms. Cardino, would you speak to that, please?
Good morning. Thank you. There are interpreting services available for this hearing. If you would like to hear the interpretation into the Spanish language and you're here in person, please come and see me and I can provide you with the interpreting equipment. If you are on WebEx, you need to press the globe on the bottom part of the screen and choose Spanish to listen to the Spanish interpretation. Buenos días, los servicios de la interpretación al español están disponibles para la audiencia del día de hoy. Si desean escuchar la audiencia en español y están aquí en persona, por favor vengan y les proporcionaré aquí los auriculares para poder escuchar la interpretación al español aquí en persona. Y si se encuentran en la plataforma WebEx, vayan a la parte inferior de la pantalla en el globo terráqueo, oprima y de ahí opriman el idioma español para poder escuchar esa interpretación. Gracias.
Thank you very much, Ms. Cardino. Let me ask first if there's anyone in the room who would like to offer public comment this morning. Please come up. Yes. And if you would press the button on the microphone in front of you so that it's green. Great. And spell your first and last name.
Excuse me, Carol, C-A-R-O-L-E, Wendler, W-E-N-D-L-E-R.
Do you swear or affirm to tell the truth?
Yes, I do.
Please go ahead. And if you're reading from something, just keep it slow.
Thank you all for the opportunity to provide comments here this morning. Again, my name is Carol Wendler. I'm a resident of Santa Fe County, and I have had asthma for pretty much my entire life. Most of the time I've had to take very little medication only really bothers me if I could have a pretty intense exercise. But in the last couple of years, that's begun to change. And I have had to start taking more medication and try to manage that a bit more. I also have a good friend who has two twin 2-year-old grandsons who recently spent about 6 days in the hospital due to severe asthma attacks. And to manage these young children's asthma, he's had to move in with his children, and help to take care of those kids. There's significant evidence that air pollution affects our health. And so I'm just one example, my friend's another example. And I just feel like in a state where people are struggling to find and afford health care, that we need to do everything we can to try to keep our air as clean as possible. Some things we probably can't address. Wildfires are a huge issue that smoke comes from outside of New Mexico, but we ought to try to address our air as best we can. So for this reason, I support updating the air quality program fees, if possible, so that the state has the resources needed to monitor and manage air pollution and enforce protections. So thank you for listening and for the opportunity to speak this morning.
Thank you, Ms. Wendler. Do we have Jerry Rivers on the platform? Jerry Rivers? No. Nini Gu?
Yes, I am
Hello.
here.
Yes, I can. Would you
Okay.
spell your first and last name, please?
Also, I am trying to start the video, but I'm clicking on the button and it's not letting me. So I guess I have to remain off video. My first name is Nini. That is Nini, N as in Nancy. Last name is Gu, Gu.
And do you swear or affirm to tell the truth?
I do.
I'll start your time.
Good morning, Madam Chair and members of the board. My name is Nini Gu, Senior Regulatory and Legislative Manager at Environmental Defense Fund. EDF is a nonprofit, nonpartisan organization that represents over 3 million members worldwide, including over 10,000 here in New Mexico, and is dedicated.
Ms. Gu, slow
Oh.
down a little bit, please.
I will, thank you. EDF is a nonprofit, nonpartisan organization that represents over 3 million members worldwide, including over 10,000 in New Mexico, and is dedicated to protecting human health and the environment by effectively applying science, economics, and the law. I am here today in strong support of NMAC's proposed increases to operating permit emissions fees and construction permit fees. From my work on oil and gas methane emissions, I have seen the importance and impact of air quality programs. Last year, Governor Lujan Grisham announced groundbreaking analysis of MethaneSat data demonstrating New Mexico's methane intensity in the Delaware subbasin of the Permian is half that of its neighbor, Texas. Results like these cannot happen without an adequately resourced and staffed Air Quality Bureau to develop and implement effective regulations. As NMAC has stated during this hearing, updates to permit fees will determine the agency's ability to maintain existing programs and continuously improve New Mexico's air quality through future rulemakings. Without EIB approval of the new fee structure, the financial cost to ensure NMAC's air quality programs stay solvent could fall on taxpayers. Already, the public must shoulder the risk of declining health, public safety, and climate impacts due to emissions from polluting industries. Both the New Mexico Air Quality Control Act and the Federal Clean Air Act intended for the regulated community to shoulder the fair cost of externalities. EDF and our fellow environmental organizations have heard so many stories from members on how air pollution has altered their lives and their communities. They rely on NMAC to be able to protect their well-being. An NMED unable to properly function in this capacity will certainly erode public trust and lead to worse outcomes for New Mexico communities. The over 300 signatures on conservation group petitions submitted to the board make this clear. Thank you.
Thank you very much, Ms. Koo. This is our final public comment session. Is there anyone else on the platform who would like to offer non-technical public comment during this hearing? Let's see, is there a hand?
Madam
Oh,
Chair.
is that you, Mr. Winchester? Mr. Winchester? Or let's see, who is that?
Madam Hearing Officer, can you hear me?
Oh, yes, now I can. Would you spell your first and last name for the record, please?
Thank you. My name is Jim Winchester, Winchester, Executive Director of the Independent Petroleum Association of New Mexico.
Do you swear or affirm to tell the truth?
Yes, I do.
I'll go ahead.
Good morning, Hearing Officer Orth, Chairman Ely, and members of the board. Nice to be back here for Air Permit Increases 2.0. We were here in October of 2024, and if you recall, IPM filed independently at that time. We're now here collaboratively with our trade partners. But in 2024, we brought before you our frustration over the lack of transparency in NMEDs coming up with the justification for their significant increases, and you all agreed, which was the fair and right thing to do. One of the things you asked NMED to do in this next iteration was to consult with industry. That never happened. Lots of letters in the file from NMED on notices, but I really would not classify that as stakeholder outreach. Now, we offered consultation in the hallway immediately following the denial in October of 2024, and they said no, and we never heard back. And now, much like Air Permit Fee Increases 1.0, we could not access key exhibits in a timely manner. You know, once again, I'm sorry, but NMED is hiding the ball and not allowing thorough vetting of their evidence. And I want to be clear, this is not an attitude towards NMED, it's just a fact. Now, the public and the regulated community deserves a transparent and accountable rulemaking process, but we feel like they're playing games with costs that have real-life implications on our operators. What we have here in 2.0 is really no different than 1.0, a lot more content and explanations, but no true technical justification. And finally, as far as the fee amounts, not much has changed in the final cost to our members. And worst of all, there's no fee difference for filing a new GCP permit for the first time versus a simple facility upgrade to improve emissions. So if our members face another $25,000 every time they want to improve emissions, what's the incentive to even upgrade a facility? So I think you can understand our frustration. I'll turn it over to our lawyers today who will present evidence, but I just wanted to publicly weigh in and give you my response from the attitude of our members and from what we are seeing. Thank you so much.
Thank you, Mr. Winchester.
Madam Hearing Officer.
Ms. Sona.
My understanding of the statute is that any person providing public comment or testifying at the hearing is subject to cross-examination. Mr. Winchester represents a party in this case, and so I would like to respectfully request to ask a few questions of Mr. Winchester.
Thank you, Ms. Sona. Mr. Winchester, I trust you're still with us.
I'm certainly
Ms.
available. Thank you.
All right, thank you. Go ahead, Ms. Sona.
Thank you, Mr. Winchester. So you took an oath when you started prior to providing your public comment, correct?
Correct, ma'am.
And in your comment, you stated that industry has tried to reach out and engage with the department, but the department has not been willing to engage back. Is that a fair characterization?
And I was talking about IPA&M's scenario immediately following the 2024 trial in the hallway when we offered that opportunity. and you said no, and we didn't hear back.
And Mr. Winchester, that was about 2 years ago, right?
Correct.
And have you been attending this hearing and listening throughout the presentation of evidence by the department?
I have been briefed by our legal team, but no, we're working on several different hearings right now simultaneously related to the administration.
So are you aware that the crux of the testimony and information presented by the department comes down to one point, which is that they are unable to balance the workload of the demands and asks from industry, given that they have many obligations under the law to provide services and protect air?
Absolutely, and I'm certainly sympathetic to that. I just think we need to find a pathway in which we have shared communication and not dictation by the department.
With that, Mr. Winchester, that statement just contradicts the position you've presented, which is that it's the department's responsibility to reach out to industry, and industry has no responsibility to reach out to the department. Can you reconcile for me why it's your position that in almost 2 years, IPA&M itself has not reached out to engage with the department on this very important rulemaking?
Madam, with all due respect, this is a petition that you guys are bringing forward, and you have not offered any stakeholder engagement. And we did raise our concerns 2 years ago. We don't know, and we didn't know what the timing was, what was going on behind the scenes. My own personal indication as to air fee permit increases 2.0 was the day you filed.
Madam Hearing Officer, I'd put to you and the board that this opinion is simply not credible. The evidence that has already been presented in this case that Mr. Winchester has not been participating in has fully demonstrated the engagement that the department has done. And so, you know, I would ask for an instruction to the board that they not consider that as anything more than Mr. Winchester's opinion on behalf of the Independent Petroleum Association, and put forward that the department's witnesses are going to be back up here momentarily. And if the board has concerns, they should ask the department witnesses directly about the level of engagement that they have had with industry. I think we've already addressed it, but they're happy to clarify.
Certainly, thank you, Ms. Sona. I think rather than an instruction from me to the board, I will invite the board to ask any questions they have of the panel, which thankfully is still in play for the final board member questions. And of course, if any board member wants to revisit that topic, they can. I do remember testimony about the engagement with industry, and would also just invite you, in the event we get to closing arguments today, that you can certainly stress things in your closing argument as well.
Thank you. Those are all the questions I had, Madam Hearing Officer. Thank you, Mr.
Thank
Winchester.
you. Thank you for the opportunity for public comment.
Thank you, Mr. Winchester. Let me ask if there's anyone else on the platform who would like to offer public comment at this time. Again, this is our final public comment session. Please raise your virtual hand. Anything, Pam? Nope. Okay. We are going to resume the technical case then. Department witnesses, if you would rejoin us on the dais. I'll begin with an invitation once you're in your seats to Member Curry to ask if he has any questions, and then we'll move to the platform. Vice Chair Sweeney had her questions asked last night, but Member Bitzer is on the platform and perhaps also Member Carrasco. Thank you, panelists. Member Curry, do you have questions of the department panel?
I do, and I have a few comments as well. I might sneak some of those in there.
Put a question at the end, maybe.
Okay. You know, I appreciate the testimony that we've heard so far. Appreciate the effort that you all put into it. And, you know, I kind of come to this place when you're talking about the Permian Basin. I'm a child of the Permian Basin and Hobbs, New Mexico. My grandfather was a wildcatter on the Texas side of it. So the work that you're doing, attempting to do, is very important. Very important. I think anybody can answer this, but just for clarity, when was the last time the regulations were, the fees were improved or increased?
That would have been 2003 and 2009, and somebody help me which one was which. It's in my testimony, so. I believe 2000, well, we'll take a look. So part 75 was 2003 and part 71 is 2009.
Thank you. I think I recall those dates. There are plenty of people sitting around this table here that were probably involved. And it was difficult then. I know it's difficult now. And one of my biggest concerns is that, and I know you mentioned this in your opening statement, that we'd just be talking about these fees kind of on an island by themselves, not the rest of the department. And personally, I think that's a very difficult challenge for you. Maybe in front of us, less of a challenge, but as it goes forward, it's going to be more of a challenge. Because when you go to implement those and have them acted on through the legislature, I don't think you can be acting in. You know, you've got a lot of support in the legislature, even to get to this point. But I think that my experience has seen, and maybe some of your experience as well, is that the legislature has a habit when they see an agency getting money that they didn't necessarily they were going to get, they take money away from that department another way, say that the money that they got through these fees is a supplemental income to the department. And so I think that's a challenge that you just have to be aware of. Again, I think if you try to present these to the legislature and to the public in general, in a void or without context, I think it's going to be more difficult to get them through, get buy-in, because you do have a very complicated budget. I told Secretary Kinney once upon a time that it made my hair hurt when I was looking at it. And it is complicated, and you have a lot of sources, and those sources sometimes are unreliable, especially if the EPA decides to play games with you. So I would just ask you, as you go forward with these, no matter what the outcome is today, because what you're trying to do, I believe, is very worthy, but I think you don't want the process to kill the worthiness of it, and the lack of context. And I just think it's important for you to do that. So if any of you would like to respond to that, I would gladly have you do that. But before you do that, I would also like to give you the opportunity, as the hearing often mentioned and as council said, is that if you'd like to take some more time to explain what you did as far as stakeholder input.
Sure. Thank you, Member Curry. And we will certainly take your advice in thinking about how we prepare our budget and how we move forward depending on the outcome today or in this hearing in the way you described, because it is complicated and it is true what you say. There is the perception that when the department receives money, some other monies have to be taken away. And that's something we'll certainly take into consideration in the budgeting process. Thank you. I'm going to ask Ms. Miano to also talk about the IPA and oh, yes. To summarize our engagement since the 2024 process, in October 2025, the New Mexico Environment Department presented at the New Mexico Oil and Gas Association Joint Committee meeting on the air fee framework that we were preparing. And my colleague, Bureau Chief Hollenberg, presented at that meeting. And then we also filed our petition. As soon as it was filed, I emailed the folks that had opposed us last time, the Mining Association, Mr. Winchester from IPA&M, and NMOGA as well, to open the door to discuss what was in our proposal and work through any perceptions from last time. I shared that we had made a lot of the changes that we had heard from last time as a result of our previous proposal. And so we were pretty excited to share those because that's what we had been asked to go back and do. So we met with the New Mexico Mining Association responded to our outreach. So we had a meeting with Mining Association team, including Mr. Sonnenberg and council from Mining Association. We also worked to we met with the New Mexico Oil and Gas Association. They also responded to our request for meetings. So my colleague, Mr. Polgar, and I met with their environment department lead that manages all of the environment department issues that the association works with the department on. So we shared some backstory on our proposal, and then that was the same day as the public meeting. So we went through we department with my colleagues here all of the different reasons why the department was going back to support or to ask the board for fees, the context kind of in the state budgeting process and why it was important for the state budgeting process. And then we also covered the specifics of the rule and the changes that we had made as a result of the industry feedback. And so we knew that the mining, we did not hear back from Mr. Winchester and the independent, the IPA&M. And so we knew from the Mining Association and the New Mexico Oil and Gas Association from our meetings with them that they were going to take what they learned from our meetings and go back to their membership and review with their membership what we had presented and what had occurred in the public meeting, and that the membership was going to make a determination what kind of position that they would take in the meeting or in the rulemaking hearing that we're in today. So we did not hear back from either the Mining Association or the New Mexico Oil and Gas Association until the filings for the technical testimony in the NOI filing date, which was February 20th. And so then on February 25th, my colleague, Mr. Polgar, and I presented at the New Mexico Oil and Gas Joint Committee meeting on our fee proposal. And we shared, where, the department was coming from in terms of needing funds. I think I explained the entire state budgeting process, and at least one member came up to me afterwards and said, I've been working in the roundhouse for 30 years and I've never heard anybody explain the state budget. And I finally understand it thanks to your presentation. So we got a lot of positive feedback, I think, at that. We also, our colleague Brett Anderson also attended that meeting, as well as our counsel, Kelly Villanueva from our from our Office of General Counsel, in case any legal questions came up. We did have a question and answer period with the membership at that presentation, and the concerns I recall were the administrative compliance costs and that policy. And then we had, and there was a question that we received about how Environment Department Air Quality Program and the NMOGA representative in charge of the electrification of the Permian projects that NMOGA is working on, how we could work together, because one of our climate action plan measures that we published at the end of last year is to bring more electricity to the Permian so that there aren't those generators out there. So there is a common alignment there that they were excited about and wanted to work together on. We also received, frankly, excitement from one of the commenters that we were going through this process, because we reflected back to the New Mexico Oil and Gas Association what their members had been telling us by way of permitting timelines, responsiveness. I recall one complaining that they still receive US mail and that there's not a way for us to communicate with them on official notices electronically under the regulation. And we said, we don't like that either. And so we said, you know, help support us in these fees, because we can work together on what it is that the industry would like to prioritize as we get this influx of funds in that we so desperately need. We'll be able to modernize in the way that industry would like. And so I think the comment was, we'll talk to you after the fee hearing. And I was like, but you could support us at the fee hearing. We all want this. But that did not occur, which is okay. So then we went to preparing for this hearing with our oral statements and exhibits and demonstratives and that sort of thing. I did see that, and our team never heard back after the February 25th NMOGA joint committee meeting on anything that we had presented. And so we just assumed that we were going to go forward with the hearing. And so we presented then we started the hearing. I did see that there was a comment filed that was posted by NMOGA that somehow NMOGA contacted our team before they filed the comments that they did, but nobody received whatever correspondence that was. And so our team looked at the letter when it was filed, and we asked ourselves who received the correspondence. Nobody did. But as it turns out, I called the secretary, and the secretary had called NMOGA to say, hey, is there anything you'd like to work through leading up to the hearing? And so it turned out that the secretary and NMOGA, Missy Courier, had a conversation. And then the secretary told her, we're happy to, receive your comments if you have any. We've been working with you throughout the last several months trying to figure out what your concerns are so that we can address them within the context of the provisions of the rule. And when I was like, oh, that's probably what the letter is referencing. And so then the secretary said that he received a call back from Missy Courier a few days before the hearing started that said, oh, we have some comments. But by that time, we were ready. We had prepared our demonstratives and everything to present our case. And so he communicated to her that, hey, we're going to hearing. So the comments that you might want to provide to us, if it's true that we need to work through some of these provisions, it's too late because we're about to present on our proposal to the Environmental Improvement Board. So that we discovered was the origin of that particular line. And so I do know that that last I heard, that Misty had sent that to Secretary Kenny, and Secretary Kenny had asked her to withdraw that particular line because he said that what is transmitted to the board in that sentence is certainly not what you and I understood coming out of that conversation. And I don't know if that's been withdrawn or not at this point, but that was we figured out the origin of the statement that NMOGA contacted New Mexico Environment Department representatives and tried to work out their comments that they submitted before the hearing. It actually was a conversation between Secretary Kenny, not our team. We hadn't received any requests from our team, the rulemaking team, nor did we receive any requests through our meeting request system that we have at the department, which is usually how we track all of the meeting requests that we receive from the agency, because there are quite a few. That's how we track the NMOGA Joint Committee meeting requests in themselves. So we hadn't received that either. And I'll turn it over to my colleagues just in case there's anything I missed from my perspective, since we've all been working together.
I would just add a little bit that in my testimony from pages 40 to 54, it goes into quite a bit of detail about what our response was to various concerns that we have heard, not only at the 2024 hearing, starting there, but then also working through the entire, 2 years almost since we've had that. We've made changes, we've done additional analysis and that type of thing to respond to a lot of concerns. And there's quite a bit of detail here. One of the things to point out, though, is that when we had our public meeting on January 15th, well, first of all, when I presented at the NMOGA meeting in October, one of the things I said at that meeting was that our proposal will look very similar to the proposal that you saw in 2024. At that point, we were still finalizing some of the details, so I didn't put out actual numbers, but that gave them the indication that, okay, we're going to be looking at something similar. At that meeting, I also invited contacts. I put up my contact information and, did not get any questions at that point. When we had our January 15th public meeting, we presented a lot of this information. I think the only thing we didn't quite have ready, because we were still working with financial staff to certify that the numbers were correct, is the actual model for costs versus revenues. So we presented all of the information that you see in the exhibit for the public meeting. We had many people attending that, but nobody really identified themselves as being from IPA&M. No questions were asked from industry at all. The only questions we received were from environmental groups or individuals very concerned about the state of the environment. We had the follow-up meeting on January 22nd, where we thought, okay, we'll give them a week to kind of digest the information that we presented. They may come up with questions later. So we had a 2-hour, basically virtual office hours, where anybody could ask a question. We didn't receive a single question in that whole 2 hours. So there were opportunities for questions to come up over and over again. And we kept making changes based on the responses that we did get, whether it was an email here or, particular questions like, okay, we can respond to that in this way. So we did make changes all the way through. And if we had heard actual proposals from any of the industry groups, we would have considered those. We can't promise that we would do everything that they want, but we do consider every single comment that we get, whether it's an email, whether it's a conversation, whether it's a meeting, whatever it is, we have been responsive all the way through.
So a couple examples in the meeting that we had with the mining folks, the question of actuals versus allowables in the Title V program came up in that meeting. Actuals versus allowables in the Title V program. And so I was explaining that our cost projection is what we need to run our program. That's one piece. The other piece is the revenue projections, which include this question they wanted to raise of should you use actuals or allowables. So beyond some of the things that have already been said about the difficulties in actuals anyway, I was pointing out that the choosing actuals versus allowables doesn't change our projected cost. That will only change your Title V fee. So we could look at that, and then we'd be looking at a much higher fee number, in addition to a ton of extra work for the department to even send out those invoices. And we also pointed out that there's some flexibility in allowables where if they can reduce their allowables to reduce their emissions. So that's one example. And then Mr. Winchester said something that I've heard in our NMOGA meetings and other areas around. I think he used $25,000. So with respect to Mr. Winchester, I believe that's the number from 2 years ago for the GCP oil and gas. The GCP oil and gas registration this year will be like 17,000. So that's one thing to point out. The other thing is, and he used a little bit of different language, but I've heard this multiple times from people about like kind engine replacements and how it's going to cost 25,000 or reality 17,000. I just confirmed yesterday with our permitting staff that that's simply not true. Like kind engine swaps, which we encourage industry to do because it allows them to maintain engines better, which reduces emissions. We have a special guidance document out there that some of you may know about that says like kind engine swaps can be processed as an administrative permit revision for which there is no charge. Technically, that's not even really allowed in the way that rule is written, not these rules, but the actual permitting rules, part 72, the construction permitting rule. So we really encourage like kind swaps and we don't charge for them. The other question, and I've said that to them multiple times, and yet they continue to say that to me. So Mr. Winchester's specific comment was about lowering emissions. That's a little bit of a different scenario because the department does have a lot more work for something like that because we have to evaluate the new equipment they're putting in, the claims they're making, are they legitimate? So there's a little bit more work involved with that kind of modification than a like kind swap. But that's not something we can address in the fee rules. So with more resources, we can and will look at Part 72 and some revisions that, as the planning section chief, I know we have some plans for Part 72 and some revisions that need to happen. This is one that we could look at and consider, and we would talk with industry about it. We would obviously encourage any way to reduce emissions, but that would need to change in Part 72. That can't change in the fee rule. And I think that's all that I need to say.
I'll also add that the department is committed after this rulemaking to continue working with industry. We do every day. And so the conversations, if they would like to continue, we are happy to continue that conversation. I think this particular rule is a little bit different than some of our technical rules, such as Part 72, because it's tied to our revenue and it's tied to what we need in the bank to begin the next state budgeting process, which forces us as the department at some point, given where we are financially, to draw that line in the sand. So even though we had to draw that line in the sand and go to hearing and move forward with presenting the proposal that we have, that doesn't stop us from continuing to work with industry on a Part 72 situation or any other matter, frankly, that comes up that we need to change. We as a department hope that we're not going to wait another 17 to 23 years to evaluate our program. So that's why we have, it's taken so long because we have not done it. And my hope is that we continue evaluating in the ways that we've described before the board, the revenue to expense, so that we can properly make sure that we have the revenue in at a more frequent time that is, you know, not every 17 to 23 years. So all this to say, even though we had to draw the line in the sand and come to the board and ensure that we have the revenue for the next budgeting cycle that we're going to be entering into shortly, that does not mean that we stop as a department from serving industry, interacting with industry, and listening to industry going forward.
Thank you. I think I really appreciate your last comment regarding what you're going to do going forward, no matter what happens. Madam Hearing Officer, I just have one more question. Just kind of back to the finances again. Do any of you know if you have any outstanding capital projects that are funded through the department regarding your?
No, to the best of my knowledge.
Thank you.
Thank you, Member Curry. Member Bitzer, on the platform, do you have questions of the department panel?
One, and maybe I just, it was said and I just missed it, but what was it, 2 days ago now? I think Senator Pope mentioned that we had a bite at this apple. He said it was last year. And I heard it again in testimony. I'm not sure who said it, but what was, can somebody do a little refresher about what derailed our move on this in the previous attempt? And was it a year ago, 2 years ago? It's not registering it with me at the moment.
Yes, when we filed the petition, it was last year. Well, 2024 was the last time we were before the board, and the department was unsuccessful in its fee proposal then because the department hadn't provided enough evidence for the board to have the board approve the proposal that we presented at that time. That was 2024. In 2025, we petitioned the board to once again hear the proposal because we had worked on the proposal since that 2024 date. And now here we're in 2026 at the actual hearing.
Oh,
So
okay.
there's been 3 years of sequence, or 2 years of sequence, since the board made its last decision.
Because yeah, it's just I mean the curve up in terms of volume of work and complexity seems pretty steep. So I'm glad we're finally addressing this. That was it for me.
Thank you, Member Bitzer. Member Carrasco, are you on the platform and do you have questions of the department panel? What? Oh, he's not on. All right. Let me ask then if any of the other board members, I know you had questions yesterday, but if you have additional questions, you're welcome to pose them. No? Vice Chair Sweeney, any additional questions? I know she called in. She may not be able to unmute on her phone, but I know she's listening. All right. Is there any reason not to excuse the department panel at this time? Oh, thank you very much, panelists. So we have 2 more witnesses in the technical case. Dr. Thompson being presented by the conservation groups, and then Mr. Sonnenberg being presented by the Mining Association. Ms. O'Grady, if you'd like to sit there, we can certainly bring, oh, is she virtual?
She is virtual, and if I may, I would love to sit there so that I can see her on
Absolutely.
the screen. Thank you.
Absolutely. Oh, you could also sit over there if the question is whether you want to see the screens. I think you can see them. Yeah, any one of these lovely seats. Dr. Thompson, would you spell your first and last name, please?
Good morning. My name is Tammy Thompson. My first name is Tammy Thompson.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Ms. O'Grady.
Thank you so much, Madam Hearing Officer. And if I may, conservation groups have very brief opening statement.
Oh, yes, absolutely.
Thank you so much. Madam Hearing Officer, Madam Chair, and members of the board, my name is Morgan O'Grady, and I'm a lawyer for the Western Environmental Law Center. I represent Citizens Caring for the Future, Earthworks, and New Mexico Interfaith Power and Light, collectively conservation groups. As you have heard over the course of this hearing, this rulemaking will determine whether the state has the capacity to detect, respond to, and prevent harmful emissions in communities affected by oil and gas pollution over the coming decades. The requested fee increases will cover the reasonable costs of the monitoring and modeling of air emissions that are foundational to the protection of human health and the environment. Today, you will hear from Conservation Group's witness, Dr. Tammy Thompson, a senior air quality scientist at the Environmental Defense Fund, whose expertise lies in monitoring and modeling of air pollution. Conservation groups extend their appreciation to the board, the hearing officer, and council for their attention to this matter. Thank you.
Thank you.
Okay. Please state your name.
Tammy Thompson.
Where are you employed and what is your position?
I am senior air quality scientist at the Environmental Defense Fund.
What is your educational background?
I have an undergraduate degree in chemical engineering from the University of Florida and a PhD in chemical engineering from the University of Texas.
Can you briefly describe your work background?
My research and professional work focus on the scientific measurements and modeling of air pollution and the development of analytical tools to inform regulatory decision-making and public health protection. My expertise lies at the intersection of atmospheric modeling, monitoring, chemical transport modeling, and policy-relevant data analysis, with the goal of identifying pollution sources, quantifying exposure, and evaluating the effectiveness of regulatory interventions.
Is Conservation Group's Exhibit 1 an accurate copy of your resume?
Yes, it is.
And Dr. Thompson, you supplied direct testimony on behalf of the conservation groups in this matter, which is in Conservation Group's Exhibit 2, correct?
Yes.
Is that testimony accurate to the best of your knowledge, and do you adopt it?
Yes, I do.
Madam Hearing Officer, I respectfully move to add Conservation Group's Exhibits 1, Dr. Thompson's resume, and Exhibit 2, Dr. Thompson's testimony into the record.
Thank you. I'll pause in the event there are objections. Okay, thank you. Exhibits 1 and 2 are needed.
In broad terms, Dr. Thompson, what opinions do you provide?
Air quality monitoring and modeling are foundational to effective air pollution regulation, permitting, and enforcement. However, the technical complexity and costs of monitoring and modeling have increased substantially as science and regulatory responsibilities have expanded. Increased emissions fees are therefore an appropriate and reasonable mechanism to ensure agencies have the resources required to fulfill their statutory obligations.
Dr. Thompson, why is it important for the New Mexico Environment Department, NMAC, to conduct air monitoring?
Air quality monitoring is the foundation on which air quality models are built, and therefore directly supports the administration and enforcement of air pollution permits. Without reliable monitoring data, regulatory agencies can't accurately identify pollution sources, evaluate compliance with permits, and design effective regulatory strategies to protect public health and the environment. More monitoring sites are needed to account for the substantial variation in air pollution concentrations across short distances and over time. An increase in monitoring sites would also better equip the state to quantify contributions from different sources. For example, to identify whether certain pollution is generated in state or out of state, or whether pollution is generated within a city or has been transported into that city from surrounding areas. These distinctions are essential for permitting and enforcement as they inform which sources and jurisdictions are responsible when exceedances occur. Another benefit of increased monitoring is that it would allow NMAC to leverage recent advances in satellite remote sensing. Satellite retrievals provide unprecedented spatial and temporal coverage of pollutants, but rely on assumptions about atmospheric structure and require validation against ground-based measurements before they can be used for regulatory or enforcement purposes.
Dr. Thompson, please explain how air quality monitoring informs air quality modeling.
Air quality models link emissions from permitted sources to ambient concentrations and then human exposure. A regulatory agency like an NMAC will use models across a range of regulatory activities, including the evaluation of permit applications. However, models are only as reliable as the data used to develop and evaluate them. The lack of robust monitoring data undermines the ability of agencies to use modeling for permit review, compliance assessment, and enforcement actions.
Could you discuss the costs associated with air monitoring and modeling?
The costs of air monitoring extends well beyond the purchase of air quality monitoring instruments. Monitoring is a multi-step technical process requiring specialized infrastructure, trained personnel, and sustained operational support. Key cost components include instrument purchase and installation, operations and maintenance, communications and data system, quality assurance and data validation, and then data analysis and regulatory modeling. Each step in this chain is essential. Data that are collected but not validated, stored, or analyzed can't be used for regulatory decision-making or enforcement. Thus, monitoring costs encompass not only hardware, but also personnel, infrastructure, and scientific analysis.
Are NMAC's existing air monitoring and modeling activities sufficient to support administration and enforcement of permits?
No, I don't think so. NMAC would benefit from increased air monitoring and modeling activities to make the most efficient and effective emissions control decisions. Specifically, NMAC needs to increase the density of monitoring, the number of air pollution species monitored, and the air quality modeling studies to better understand the relationship between these permitted emissions and air pollution throughout the state. Without sufficient funding for these activities, NMAC cannot evaluate permit applications and cumulative impacts, detect violations or emerging pollution trends, or adequately protect public health and the public interest.
Turning to the proposed rule, do you support the proposed fee increases at 20.2.71 and 20.2.75?
Yes, I do. Air monitoring and air modeling are key to the design of effective and efficient air pollution policy. Increased fees will provide the funds necessary to support the agency's statutory obligations.
This concludes Dr. Thompson's testimony. Dr. Thompson now stands for cross-examination and questions from the board.
Thank you very much, Ms. O'Grady and Dr. Thompson. Mr. Mullenberg, do you have questions of Dr. Thompson? Thank you. Mr. Weatherby, on the platform, do you have questions of Dr. Thompson?
No, I don't, Madam Hearing Officer. Thank you.
Thank you. Ms. Tona, do you have questions of Dr. Thompson?
No, I do not. Thank you, Dr. Thompson, very much for your testimony.
Thank you. Member Curry, would you like to begin any board questioning? He has none. Member Garcia.
I don't have a question. I just want to say thank you for your testimony. We appreciate it. Thank you.
Chair Ely.
Just one question, Dr. Thompson. We're bumping up against ozone, getting into the territory of ozone nonattainment down in the Permian. There are 2 monitors down there right now. Do you have a sense of how many monitors you think would be needed to better assess those ozone levels and potential locations for those monitors?
So you have 2 more than Texas has on the Texas side, right? So that's a start. But so I think that your team has the right approach to answering that question. I think that, with additional satellite data, you can get a spatial layout of what the ozone looks like and use those monitors to support that information. But additional monitoring of both NOx and VOCs across the area will help you understand that spatial pattern, but also what's causing the ozone formation and how best to cut the formation of ozone, which species of precursor would be best cut to decrease that ozone production in the area. That's the tricky part with ozone, that it is formed from NOx and VOCs, and understanding which is the driving species can be challenging. And so I think the monitoring approach should take that into account and include monitoring of both the precursor species in that area to better understand that. But as far as the exact number, more is always better. There's obviously a limit there, but including those precursor species, I think, will be very important.
Thank you. Vice Chair Sweeney, I see you've transitioned from the phone to the computer. Do you have questions of Dr. Thompson?
I don't, Madam Hearing Officer, I don't have any questions. Just want to thank her for her testimony. Thank you.
Thank you. Member Bitzer, do you have questions of Dr. Thompson?
I do not. Thank you.
All right. Anything further, Ms. O'Grady?
Nothing further. Thank you so much.
All right. Thank you. It is almost 10 after 10, and we do need a morning break. And then we'll hear from Mr. Sonnenberg. So let's all trade places and take a break until, let's see, what would that be? About 20 after 10? Thank you. All right. Thank you. Let's come back from the break, please. When we broke, we had completed the presentation by the conservation groups. We move now to the New Mexico Mining Association. Mr. Molenberg.
Thank you, Madam Hearing Officer. We've got a few things to do that I think will close out the this part of the public hearing. We have a witness to present on behalf of the New Mexico Mining Association, Mike Sonnenberg. I have a brief opening statement for the Mining Association, and then we also have opening statements for NMOGA and IPA&M. And I'll be doing the NMOGA statement. Ms. Saluha will be doing the IPA&M statement. We can do those in any order.
Why don't you choose?
Okay.
Madam,
Ms. Sona.
I was going to request that if Mr. Molenberg and Ms. Luda could provide their opening statements before we turn to the testimony for Mr. Sonnenberg, I think will help make the questions I have a little more seamless, given some of the crossover.
So is that okay with you?
That's okay. We can do it in any order. Are you thinking of all 3 opening statements or just the Mining Association?
You have Three?
Yeah.
Yeah.
NMOGA, IPA&M Mining Association.
I apologize. That was not my understanding from our first day. I'm not sure what there's even in the record for an opening statement for IPA&M that's not going to end up with council testifying.
No,
we heard from Mr. Winchester. So a party filing just to be able to make an opening statement and avoid the 3-minute limitation is pretty prejudicial.
I guess I disagree with you on that, Ms. Sona. Let's hear what Mr. Mullenberg has to say. Any order you'd like, Mr. Mullenberg.
Okay. Why don't we start with the 2 oil and gas opening statements then? And obviously, I think the board knows council statements are not testimony. They're opening statements and should be taken as such. And let's go from there. So let's start with IPA&M.
Good morning, Madam Chair and members of the board. My name is Serafina Saluja, and I am here on behalf of the Independent Petroleum Association of New Mexico, or IPA&M. IPA&M would like to reiterate that many of the concerns raised during the prior proceeding remain unresolved. At that time, stakeholders highlighted the lack of transparency in how the department developed and justified its proposal, and the board rightly emphasized the importance of greater openness and meaningful engagement moving forward. Unfortunately, the current proposal reflects many of those same deficiencies. While the department has provided more narrative explanation, stakeholders were not meaningfully consulted in advance, and key supporting materials were not made accessible in a timely manner to allow for informed review. Notices alone do not constitute true stakeholder outreach, and without access to the underlying data and technical analysis, it is difficult, if not impossible, to fully evaluate the basis for the requested fee increases. In the end, this proposal appears to be a continuation of the prior effort with additional explanation, but without the transparency or substantive justification needed to support it. That lack of clarity undermines confidence in both the rulemaking process and the outcome. For these reasons, IPA&M respectfully urges the board to reject the proposal and require a more transparent, data-driven approach before considering any future fee increases. Thank you.
Thank you, Ms. Saluja. Mr. Mullenberg.
Thank you, Madam Hearing Officer. I'm now going to provide an opening statement on behalf of the New Mexico Oil and Gas Association, or NMOGA. NMOGA represents members engaged in all aspects of the oil and gas industry, including upstream operations such as wells and associated tank batteries and separation facilities, midstream operations such as pipeline systems and natural gas processing facilities, and the single downstream petroleum refinery in the state. NMOGA's members hold most types of the air quality permits discussed in this hearing and must pay fees in accordance with the existing rules and any new rules adopted by the board. NMOGA recognizes that the department relies on fee revenue to support a large portion of its air quality program and shares the department's and the public interest in having an adequately funded department to fulfill its statutory duties. For NMOGA, the question is not whether there should be some amendments to the fee rules to generate additional fee revenue to support air quality programs. The question is how much of an increase is needed and how quickly. NMOGA has some concerns regarding the rule development process, which have been expressed to the board. including NMOGA's joinder in the Mining Association's response to the department's motion in limine. As discussed in Ms. Hollenberg's testimony on stakeholder outreach, the regulated community first received the department's proposed changes to the fee rule when the department distributed its petition after filing it with the board. NMOGA representatives met with the department representatives in January of this year after the petition was filed, and that's been covered in the department's testimony. But the department had limited information to provide at that time, and I think that was also discussed this morning. NMOGA did not see the detailed analysis and projections that the department provided in this hearing until the department filed its technical testimony on February 23rd. That was a large filing that took time to distribute to members, review, and get comments back from members. The stakeholder approach, unfortunately, and let me interject a personal comment. I think the stakeholder process has become somewhat of a red herring here. It's become kind of an excuse for all sides to blame the other for not getting it done. But I think the issue is really, how do we get to effective stakeholder negotiations? And the time pressures of the rulemaking, unfortunately, and the rulemaking process are not really helpful with that. NMOGA has, in its joinder in the Mining Association response to the motion in limine, and in its closing arguments that we've just filed along with a legal brief, believes that the rulemaking approach being taken here is not consistent with the meaning and intent of the State Rules Act and the board's hearing rules, and we've discussed that before. NMOGA submitted written comments in this proceeding urging the board to take a more measured approach and not increase fees to the full extent requested in the department's proposal. Part of the reasoning for a measured approach is based on the past history of fee revenue going into the special revenue funds compared to expenditures from the funds. The history over the past several years is that fee revenue exceeded expenditures drawn from the special revenue funds, resulting in a growing balance of funds. There may be several reasons for this, but NMOGA does not see a clear explanation in the record. More recently, the data presented by NMED shows that expenditures are increasing and fund balances are decreasing. NMOGA views this as a positive development that should put fee revenue to a better use. NMOGA disagrees, however, that this very recent trend presents a crisis. It is true that if fee revenue does not increase, at least to some degree, and other sources of funding are not found, there could be a revenue gap, and eventually NMED could have to cut back on expenditures to avoid a fund deficit if fees are not increased. NMOGA doesn't want to see this happen any more than does the department. But the information presented by the department indicates that the most recently supported fund balances are still high enough so that the balances that have accumulated in the special revenues funds over time would support expenditures at the levels projected by the department for some time, even if the board chose not to amend the rule at this time. Regulated industry sees a real risk, supported by the history of these funds, that if fee revenue exceeds expenditures and fund balances once again balloon, there's a risk of funds being swept by the legislature. While it's common knowledge that the state recently has been the beneficiary of robust state revenues, mostly generated by the oil and gas industry, that have allowed the state to expand many programs that benefit its citizens, history also shows that there is no guarantee that the current situation will continue. History shows that the state is likely in the future to experience a budget shortfall. When that happens, the legislature may decide once again to sweep funds that have accumulated in special revenue funds in order to avoid cutting other programs. Both of the air quality special revenue funds have been swept before. Fortunately, due to federal restrictions on the use of the Title V funds, and as a result of an EPA review, the legislature had to return the swept Title V funds. The construction permit fund was not so lucky, as the swept funds appear to have never been replaced. When funds containing fee revenue are swept, the regulated industry often ends up paying twice. Once to pay the fees that resulted in ballooning fund balances, and a second time if fees are increased to make up for swept funds. Thus, regulated industry has a real interest in seeing that excess fee revenue does not accumulate in a special revenue fund, resulting in a fat target for a legislative sweep. The department has presented a 5-year plan with projections of very large increases in both fee revenue and expenditures. On the expenditure side, NMOGA has concerns with both the ability of the department to execute on its spending plans and regarding the magnitude of some of the proposed expenditures and whether they should be funded by fee revenue. Past history shows that the department has struggled to fund authorized positions and meet its expenditure targets. Recent history indicates that the department's execution is improving, as shown by reduced levels of vacant positions. But vacant positions are still a problem for some functions, such as inspections. If the department has continued difficulty filling positions going forward, fee revenue may again exceed expenditures and fund balances may rise due to the unexpended fee revenue. NMOGA also has concerns with some of the expense estimates presented by the department. Perhaps the most notable is the planned contractor expenditures of $8 million per year over the 5-year period. This figure is multiple times contractor expenditures shown in any prior year. The department has testified that contractors are used when department employees cannot perform the needed work.
Mr. Molenberg?
Yes.
The interpreters are asking that you slow down.
Okay, thank you. It is logical that if the department is able to carry out its hiring plans, it will have more employees to perform the necessary work, and that the department will need fewer, not more, contractors over time. Consequently, NMOGA questions whether the record provides a basis for this level of contractor expenditures in the future. This is important as the $8 million is a substantial part of planned annual expenditures. And if the department does not need contractor assistance due to increased staff levels or is otherwise unable to expend those funds, that will be another reason for accumulation of excess revenue in the special revenue funds. NMOGA also contends that the department is stretching the legislative language regarding the basis that the legislature has specified in its authorization to the board to adopt setting fee schedules. This issue is addressed in a legal brief and closing argument that has been now filed in this matter. For these and other reasons, as expressed in its written comments, NMOGA proposes a slower and more measured approach by the board. First, NMOGA proposes that the board adopt a rate of $60 per ton of allowable emissions rather than the $85 per ton rate proposed by the department. At $60 per ton, that would still be an increase of 50% over the current rate of just over $40 per ton. That would still allow for substantial growth in Title V fee revenue. Also, NMED has indicated that it is willing to make annual reports to the board regarding program expenditures and fees. NMOGA agrees that this is an important factor and really appreciates the department's markup of its proposed rule and the testimony we heard yesterday on this report. Now that the department has developed forward projections of fee revenues and expenditures, which the board sought at the last hearing, and if the board accepts that approach, the board will be more readily able to make further fee adjustments if warranted. That is a more measured approach that still will allow substantial growth in fee revenue to support more staff and expenditures for the Title V program. NMOGA would note that the number of Title V facilities seems to be relatively stable based on the information the department has presented. For the construction permit program, it appears that one of the larger components of increased fee revenue is the proposed tripling of the points and resulting fee for registering oil and gas facilities under the oil and gas GCP. In response to this, and consistent with the overall approach that NMOGA recommends only a doubling of the points from 10 to 20 rather than to 30. NMOGA also expressed concerns and had questions regarding the assessment of fees for relatively minor permit changes. NMOGA appreciates the testimony yesterday and again this morning that the Air Quality Bureau does not assess fees for notifications of minor facility changes for GCP facilities, and the testimony that the Air Quality Bureau generally does not assess fees for minor administrative type changes to construction permits due to minor changes. NMOGA will watch to see that that practice follows the representations in the testimony, but really appreciates that Air Quality Bureau intends not to impose substantial fees for minor changes. NMOGA's written comments also suggest some additional language for the proposed rule language concerning the Air Quality Bureau's discretion to charge additional fees for a change in an application. Commissioner Garcia raised a question yesterday whether the language in the proposed rule is nebulous and whether some additional criteria for the Air Quality Bureau's exercise of its discretion is warranted. NMOGA's written comments is an attempt to provide language to provide more criteria on that point. That's all I have. NMOGA really appreciates all of the work, first of all, that the department did and the testimony of its witnesses here. We do have a lot of information now in front of the board to consider. And NMOGA very much appreciates the board's time, attention, and work on this matter. Thank you very much.
Thank you, Mr. Mullenberg.
Madam Hearing Officer.
Ms.
Unfortunately, the danger that I just raised has now been fully and apparently raised. What was offered as an opening statement was rebuttal testimony. It is a flagrant procedural violation. What is happening here? The opening responds directly to matters that have been discussed during this hearing. The public comment that was raised was filed while we were in public comment Monday morning. It wasn't even provided to the department before. The legal brief mentioned was filed this morning during public comment, where I've been here representing the department and unable to review it. The surprise, the gamemanship, it's very prejudicial to this process. Information presented in the opening is absent from this record and is absent from NMOGA's public comment, which is only 3.5 pages long. It's very short. It goes above and beyond what is intended. In fact, the public comment allows them to hide behind a process available. I'm not disputing that public comment is available, but what it means is now the department cannot test that perspective being made under oath to draw out the full truth and accuracy of it. It's effectively rebuttal being offered very late in the game. We had to file February 20th notices of intent that set forth our testimony, that set forth the procedural, the rule that we want the department to consider, and to set forth a statement of reasons. Now, in the middle of this hearing, we have a party, not just a member of the public, filing what is effectively an NOI during the hearing. It's a flagrant procedural violation that all the information is out there now. I'm not sure what the cure is that I can ask for that's going to remedy this besides striking it or an instruction for the board to not consider it. It's mind-boggling that $1 billion industry had to wait until now to share what it thought with the department when the department's been here saying we don't have enough money to be able to even fully meet with industry. So I put it to you for your position on how we can address this major.
All right, thank you, Ms. Sona. Mr. Muhlenberg, let me just choose one example from your statement just now that the members of NMOGA would suggest, for example, that the GCP points be doubled instead of tripled, 10 to 20 instead of 10 to 30. I think I heard you say that. Is that in the public comment? Is that somewhere else in the record that maybe I didn't catch? Where would that be?
Madam Hearing Officer, that is in the written public comments that NMOGA filed.
Okay.
So,
Okay, so thank you for that answer. So the board members then can, I'm sure they've already looked at the comment when they deliberate. They can look at the comment. They can decide for themselves and in consultation with their counsel as to whether that's the sort of thing they can rely on in making adjustments to the proposed regulation. So thank you for putting your objection on the record, Ms. Stone. I really do think the board, again, particularly in consultation with their counsel, is sufficiently sophisticated to winnow and sift what they have in front of them, knowing that, for example, there was not a technical witness presented on behalf of NMOGA. It was a public comment.
correct. I mean, that's part of our process. The board can, I mean, obviously my opening statement is not testimony. I did my best to tie the discussion to the written comments and to other things that we've heard during the hearing and that are in the record. I would fully acknowledge that the board has to base its decision on the record itself, which I believe includes written comments, given the weight that the board assigns to them. So
exactly.
Yes.
Thank you very much for that. We're going to move on. Do you have an opening statement for the Mining Association?
Yes, Madam Hearing Officer, wearing lots of hats today. Again, good morning, Madam Hearing Officer, Madam Chair, and members of the board. I'm here to help the New Mexico Mining Association and represent the New Mexico Mining Association in this proceeding. The New Mexico Mining Association will present a technical witness, Michael Sonnenberg. Mr. Sonnenberg has testified before the board before in the previous proceeding on fees. And Mr. Sonnenberg has a number of comments on the rule on behalf of the Mining Association. As he'll clarify, and again, this is kind of a function of the process, the technical testimony he's going to give was prepared before the department had filed its notice of intent and testimony, so it should be viewed in that context as well. At any rate, let's just go to Mr. Sonnenberg. He's really going to express the Mining Association's views, I think, much better than I can. And let's just go straight to that, and I'll introduce him. So the Mining Association calls Mr. Michael Sonnenberg.
Thank you. Mr. Sonnenberg, would you like to sit up here at the dais? If you would spell your first and last name, please.
Sure. Michael, Michael, Sonnenberg, Sonenberg.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Mullenberg.
Thank you, Madam Hearing Officer. Mr. Sonnenberg, on whose behalf are you testifying today?
I'm testifying on behalf of the New Mexico Mining Association.
And by whom are you currently employed?
I am currently employed by Freeport-McMoRan.
Did you provide a resume filed as NMMA Exhibit 1 stating your employment history, qualifications, and experience?
Yes, I did.
Did you provide written direct testimony that was filed in this matter as New Mexico Mining Association Exhibit 2?
Yes, I did.
Do you have any corrections to your written direct testimony that you'd like to call to the board's attention?
Yeah, I have a few corrections that I'd like to call to the board's attention. The first one being that I made a statement in the written direct testimony that the administrative cost recovery provision was likely unlawful. As there was some discussion here earlier, I'm not an attorney. I can't make determinations of law here. And so I withdraw that. Furthermore, I included other discussion about the administrative cost recovery provisions, which was based on the proposal available to me at that time. NMAD has since removed that from their rule, and so I withdraw all those comments as well. And finally, the last correction I would like to make is that I made a statement in my written testimony that Freeport-McMoRan had given up or canceled their Title V permit as a result of having a meeting with NMAD, where we were told if we didn't like the permit fees, we could reduce our emissions or remove the permit. There is currently some debate about what the status of the Title V permit is. So in the rules adopted by the board, and the reason I made the statement I did is in the rules adopted by the board for operating permits, it says that upon request of the permittee, the department shall permanently discontinue the Title V permit. And we made that request prior to me filing direct testimony, and we thought that the Title V permit would therefore be permanently discontinued. The department has since then reached out to us and said they didn't want us to discontinue the Title V permit. They have written several emails to us demanding that we withdraw our request to discontinue the Title V permit, including this week during the hearing. And I think that this is an attempt to influence my testimony and intimidate me as a witness. Because we met with the Environment Department and they told us we could get out of the Title V permit. What the department suggested that we do is we apply for a significant permit revision and conduct modeling. The reason we are no longer subject to Title V is because we went back to Tyrone. We found 9 engines that are no longer being used, and we are removing those from the permit. The department wants us to conduct modeling for a facility that's already been modeled, to removing those 9 engines, to show that removing 9 engines will not adversely impact air quality, which, based on the way the model works, is not something that is possible. So that to me just seems like a waste of time, a way of delaying the process, and it doesn't seem to serve any public health or public policy goal that I can think of.
Thanks, Mr. Sonnenberg. With the corrections you've just discussed, do you adopt your written testimony as your own testimony here today?
Yes, with the corrections I stated.
At this time, I would move for admission of, well, let me ask you one more question. There are a few more exhibits that were filed by the Mining Association. Are those exhibits referenced in your written testimony?
Yes, they are.
Thank you. At this time, I would move to admit the New Mexico Mining Association exhibits 1 through 8.
And pause in the event there are objections.
Thank you, Madam Hearing Officer. There are objections. I can run through them. So the department filed a motion in limine, which we discussed the first day of the hearing. Pages 7 and 8 of that motion in limine bullet point the exact quotes from Mr. Sonnenberg's testimony that adjust where he is making legal analysis, legal interpretation, or legal conclusions. My takeaway from your instruction was that all of those issues should be addressed, and he should be no longer offering opinions such as EPA Inspector General found that New Mexico was unlawfully spending title funds. That those opinions were not permissible from a witness. The correction I heard only addressed one of the bullet points, which was the same bullet point that that Mining Association had already agreed was a topic they weren't going to testify about orally today. So I would continue my objection that's made in the motion in limine. I'd also continue my objection regarding the speculative testimony as the evidence that's been offered to support the testimony does not demonstrate support for all of the opinions that Mr. Sonnenberg is offering, in addition to the fact that the opinions being offered are speculative in the sense that they have been fully disproved already in this hearing with the testimony we've heard. And so it's not helpful for the board to hear those. I think that's it.
All right, thank you. As to the Inspector General report, I believe it speaks for itself. So unless, if it says, in fact, the department was unlawful, that's what it says. That's a fact rather than an opinion. If this is Mr. Sonnenberg's characterization of the Inspector General report, however, or reflects on the agency rather than on the legislative sweep, for example, then that is not appropriate. In any event, yes.
I'm sorry. Just to add for your clarification, that report is an example of something not in the record for us to test whether or not this is what the Inspector General said or whether this is Mr. Sonnenberg's opinion. So again, that goes to the problem that I'm saying.
Okay, thank you. In that case, then his characterization of something that's not in the record becomes more problematic. I'll let you address that, Mr. Moldenberg, as you see fit. And as to the speculation, that obviously has a lot more angles to it as we go along. Why don't you elicit an acknowledgement as to some of the speculation when you cross-examine, if you would. Go ahead, Mr. Mollenberg. Oh, so exhibits 1 through 8 are admitted with the adjustments offered by Mr. Sonnenberg.
Thank you, Madam Hearing Officer. Mr. Sonnenberg, do you have a summary of your written testimony to present to the board this morning?
I do.
Please proceed.
Okay. Good morning, Madam Hearing Officer, Madam Chair, and members of the board. My name is Mike Sonnenberg, and I am here on behalf of the New Mexico Mining Association. As evidenced by my resume, I have extensive experience in air quality permitting and regulatory programs, including managing Title V and construction permitting programs.
Mr. Sonnenberg,
oh,
you're going to have to slow it down.
All right. I'll let him catch up. As evidenced by my resume, I have extensive experience in air quality permitting and regulatory programs, or managing as both a state regulator and industry representative. I also testified as a witness in the previous New Mexico air permitting fees hearing, and it is nice to see you all again. NMMA is participating in this proceeding because its members fund the state's air permitting programs and therefore have a strong interest in ensuring the fees are reasonable and transparently administered. In short, NMMA's review of the available financial data raises concerns that the New Mexico Environment Department has accumulated significant fund balances without clearly demonstrating how those funds are being spent or why additional revenue is necessary. We are concerned that these fund balances will continue to increase if funds are raised. Overall, NMMA finds the department's proposal to be vague and insufficiently supported. And again, this was the information available at the time of the direct testimony. The proposal does not clearly explain how increased revenues would be allocated, how staffing increases were justified.
Please slow down again.
Or why existing resources are inadequate. This lack of detail makes it difficult to evaluate whether the proposed fee increases are reasonable or necessary. Change the slide. This slide shows the Title V fees funds for the past 10 years. We got this from the New Mexico State Auditor's website. With respect to Title V operating fees, the proposal would significantly increase costs, potentially by 4 to 5 times for some facilities, through higher per ton fees and the addition of new fee pollutants. NMA's analysis of historical data does not support the department's claim that the Title V fund is at risk of being depleted. Our review of the state auditor report shows that revenues have exceeded expenses for 4 of the last 5 years, and the fund has a comfortable balance of over $7 million. Additionally, the current accounting structure makes it difficult to determine whether Title V fees are being used solely for authorized purposes, raising transparency concerns. Next slide. Similarly, for construction permit fees, NMMA does not find evidence supporting the department's projection that the fund will be exhausted. Our review of the state auditor report shows that revenues have exceeded expenses for the past 10 years. Historical data shows substantial growth in the fund balance. While most proposed fee changes are modest, NMMA agree, while the proposed fee changes for the construction permit program are modest, NMMA raises concerns about transparency and fund tracking. Next slide. We also compared NMED's fund balances to 2 nearby states. New Mexico's funds exceed both of them. One state's fund received a cash infusion from the legislature to implement technology upgrades, and it will drop even further by the end of this fiscal year. To address our concerns, NMMA proposes enhanced annual reporting requirements, which we've discussed for the Title V and construction permit funds, to ensure transparency, accountability, and informed decision-making by the Environmental Improvement Board. NMMA recommends that any future fee increases be contingent on the department providing clear financial reporting. In summary, NMMA does not support the proposed fee increases as presented due to insufficient justification, lack of transparency, and instead urges the adoption of reporting requirements for a more data-driven approach before any fee increases are approved. Thank you for your time, and I look forward to answering any questions you have.
Mr. Mullenberg, I see one more slide though.
Oh, I apologize. Yes, so this gets into what I just said about the enhanced annual reporting, and I think this has been discussed. So this is the provisions that are in our proposed rule for the construction permit fee fund and the Title V fund.
Is that all, Mr. Mullenberg?
Yes, thank you, Madam Hearing Officer, and thank you for the reminder. The witness is now available for questioning.
Thank you very much. Ms. Sona, would you like to begin?
Thank you, Madam Hearing Officer. Usually NMAC goes last for cross-examination.
Oh, I'm sorry. I had forgotten. Ms. O'Grady, do you have questions? Yes.
Good afternoon, Mr. Sonnenberg.
Good afternoon.
How are you today?
I'm doing okay. A little bit nervous, but that'll pass.
Okay. Mr. Sonnenberg, on page 8 of your testimony, you stated that based on a review of the state auditors general's reports, it is not possible to determine how Title V fund revenues are being spent, correct?
Yeah, that's correct.
And on page 16 of your testimony, you state that based on a review of the state auditor's reports, it's not possible to determine how construction permit fund revenues are being spent.
Yes, that's correct.
Mr. Sonnenberg, are you familiar with the New Mexico Inspection of Public Records Act?
Yes.
Did you or the New Mexico Mining Association attempt to request agency records related to spending of Title V fund revenues or construction permit fund revenues prior to drafting your testimony?
No, we did not. We didn't feel like we had enough time. When we've made those kinds of requests in the past, it's taken very long to get back to us. When we did this in 2024, we filed a request for public records. And if I recall correctly, we didn't get the records until after the hearing had already happened.
Mr. Sonnenberg, for how many months or years has this rulemaking been in the works?
My understanding is the rulemaking started last month.
And was the agency preparing to file this rule for many months or potentially years leading up to the filing?
I don't know.
If there were a window where the agency were preparing for this rulemaking and coordinating with conducting outreach to regulated entities, potentially that could have been a notice to the New Mexico Mining Association to request records they might want in crafting their arguments for this case?
Yeah, so we did meet with the Environment Department in January. At that time, they had represented to us that there was an analysis that had been done by Mr. Polgar to justify the fee increases. And we asked for that in that meeting, and they told us that they would not provide that, is my recollection.
And
so that wasn't through a New Mexico Public Records Act, but that was a request in a meeting.
I think that oral requests, well, strike that. But the New Mexico Mining Association also decided at that time not to request any other records that might be considered public under the Inspection of Public Records Act.
Other than, yeah, what we requested in the meeting, no.
Okay, thank you. I just have one more
Okay.
set of questions for you. Thank you so much for your time. Mr. Sonnenberg, on page 18 of your testimony, you state that it is unlikely that fund increases can be used to invest in compliance assistance and assurance efforts such as optical glass imaging and remote satellite sensing. Is that correct?
Yes.
And you stated that this is the case because the primary source of additional funding under the proposal comes from increased Title V fees, correct?
Yes, that's my understanding based on the information available at the time.
And you stated on pages 18 to 19 that fees from the Title V permitting program cannot be spent on general air quality planning activities such as regional photochemical modeling or monitoring, correct?
Yes, that's correct.
Mr. Sonnenberg, you testified on page 6 of your testimony that the Clean Air Act, Section 502B3, requires state air permitting programs to establish fee structures that are sufficient to cover the costs of running the state's Title V air permitting programs. Correct?
Yes.
So you are familiar with the language of the Clean Air Act governing the use of fees generated by Title V permits?
Yes.
Would you agree that this statutory language, which for those following along can be found in the record at NMED Exhibit 7C, actually states that fees must be, quote, sufficient to cover all reasonable direct and indirect costs required to develop and administer the permit program requirements of this subchapter?
Yes, that's correct. I think the connection you're trying to draw is not accurate in the sense that things like planning or remote sensing or things like that are not part of the Title V program, either a direct or indirect cost.
Would you agree that the list of explicitly identified costs following this provision includes, quote, emissions and ambient monitoring?
Yes, I agree with that as it relates to the Title V permitting program. It's not general air quality modeling. So monitoring, air quality monitoring that the department is talking about, just general what's going on in this area. Are we in attainment? Are we not in attainment? That's Title I of the Clean Air Act. And this is Title V of the Clean Air Act. They're two different programs.
And on what do you rely for your definition of indirect costs?
I think the same EPA guidance that the department is looking at.
Okay, thank you. I have no further questions.
Thank you, Ms. O'Grady. Mr. Weatherby, do you have any questions of Mr. Sonnenberg?
Madam Hearing Officer, I just wanted to follow up on a question relative to the testimony that in the response to the questions of the previous questioner relative to inspection of public records. And Mr. Sonnenberg, was it your contention that there was an attempt through IPRA or Inspection of Public Records Act back in the previous rulemaking process that you didn't get a response to on time?
Yes, that's correct.
And do you understand that?
I'm sorry, Mr. Weatherby, hold on a second. Ms. O'Grady?
I believe redirect often occurs after all questioning occurs. Is that correct?
Redirect? This is Mr. Weatherby?
Apologies, Mr. Weatherby. Thank you.
Go ahead, Mr. Weatherby.
Yes, I actually I found it important what the previous questioner had asked about that. And the reason I'm asking that is, under the IPRA statute, was it clear to you that the agency, even though they may have not got back to you in time, had a responsibility to still provide those records to you?
Objection, Madam Hearing Officer. I believe along the lines of what Ms. O'Grady was going to object to is that friendly cross-examination is not appropriate as it's not helpful.
Oh, well, all right. As you know, the parties are arrayed on a spectrum of more supportive to less supportive, or vice versa, of the petition. And I think Mr. Weatherby is entitled to pursue a few questions here. Mr. Weatherby, go ahead.
Thank you, Madam Hearing Officer. Again, I asked that question, let me rephrase it. To your knowledge, was the IPRA response received even if it was after the previous hearing? Did you receive one?
Truthfully, I don't recall. I believe it did come through after the hearing. That is my recollection. But this was a year and a half ago, 2 years ago.
And is there any reason you wouldn't have followed up and used that information? It just seems to me that it's a bit of a red herring to say you didn't get something in the previous one when they didn't get it to you on time, but in fact, you still had it for information that could be used in the current one. Could it not have?
I suppose so, if we had it.
Okay, that's it, Madam. Thank you.
All right, thank you, Mr. Weatherby. Ms. Sona, I believe we've come to your questioning.
Thank you, Madam Hearing Officer. Morning, Mr. Sonnenberg. We're still morning. It's only 11:13. Good to see you again. My name is Kelsey Sona. I'm with the law firm Robles, Ryle, and Anaya, and representing the department. I believe we read briefly at one of the meetings that's been discussed.
Right. Yep.
Thanks. So I have quite a few questions to ask you. I do want to try and get through them quickly because you covered a lot of topics in your testimony. If you could listen to them carefully and provide just your brief answers. If you need me to clarify, let me know. I'll do my best to not talk over you. If you could do your best to not talk over me. So let's get started.
Okay.
Just to keep us on the same page, I briefly want to address two things that you said just a moment ago. And regarding the analysis that you stated you requested from the department orally during a meeting, it's not true that the department denied you that analysis. In fact, the department said the analysis was not done, so there was nothing to provide. Correct?
That may be true. We did not get the analysis prior to seeing it filed.
Okay. And regarding your the information you shared about the mine where you were seeking to withdraw the Title V permit, do you recall that?
Yes.
Is that the Chino mine or the Tyrone mine?
That's the Tyrone mine.
Okay. And your characterization of it was that you were asked to withdraw documents and the department was making demands of you. But really, in fact, the department was just asking you to comply with the rules that they're charged with implementing, right?
I disagree with that. So the rule says upon request of the permittee, the department shall permanently discontinue the Title V permit. There's nothing more. I don't get how the department can say that we're not complying with something. We have made a request to discontinue the Title V permit.
Are you offering your legal opinion, Mr. Sonnenberg, about the rules, what the rules say? Or
I'm not offering an opinion. I'm giving a verbatim description of what the rule says. Upon request of the permittee, the department shall permanently discontinue the Title V permit. I have no idea what that means. I'm not an attorney, but that's what it says. Upon request of the permittee, the department shall permanently discontinue the Title V permit.
You're a prior regulator, right, Mr. Sonnenberg?
That's right.
Okay. And so you're really familiar with the incredible complexity of Title V programs, right?
Yes.
Okay. And so it's fair to say there's likely a lot more to this process than what you're representing is a single line in a rule that we don't have a citation to, correct?
We can provide the citation. The department has not provided what that is. They have not provided an analysis. They have asked us to do a significant permit revision to the NSR permit, which is a different permit, which means that we have to model a facility that's already been modeled and remove 9 engines that are being removed from the site. So that seems to me,
Madam Hearing Officer, because unfortunately, I'm not getting responsive answers to my questions, and it's simply false. As well as I can try and correct false testimony on the record. I don't think this is fully relevant to the board's decision making.
So I was about to ask you if perhaps you should move on insofar as it really is a peripheral matter.
Yeah. So it goes to the dangers that we're dealing with in this hearing of so much testimony being thrown out at the department that's irrelevant, that we're forced to have to draw out the negative, that it's just not true.
Okay, thank you. Mr. Mullenberg?
Thank you, Madam Hearing Officer. Just a brief response, because I think this is a peripheral issue. Again, this came up in a context of a statement made by Mr. Sonnenberg in his written testimony, which he needed to clarify. That's really the only issue here, and I don't think we need to belabor this further.
I agree. Ms. Sona, if you would move on, please.
Yes, I'm going to. Thank you, Madam Hearing Officer. Mr. Sonnenberg, did you draft your testimony on your own?
yes.
Did anyone help you with any portion of your testimony?
No. I mean, I had others kind of review it after it was written, but it's mine.
Did you attend the 2 public meetings held by the department on January 15th and January 22nd, 2026?
No, but I do believe that our Dal attended those and provided some summary to me.
Are you aware that no one in those meetings identified themselves through the labeling of their name or orally through questions as representing the Mining Association or any of its members?
I'm not sure if you say it, I believe you though.
You would agree that these meetings would have been an excellent opportunity to ask questions about much of what your testimony covers, correct?
Yeah, we felt that our meeting with the department separately kind of covered those same topics. I did also review the presentation that was made because that was posted online. And I didn't see anything different from kind of what we had, the discussion that we had separately.
And did you attend the hearing over the last 2.5 days?
I attended parts of it. Other parts I listened online.
Did you hear the public comment made by a prior employee of the Freeport McMoran Copper and Gold mine, where he shared his experience being in the room with engineers and leadership from the mine regarding how decisions made by industry cannot be trusted because they cannot regulate themselves and they need a firm hand from the state?
I remember testimony to that effect. I don't remember it being a Freeport employee or a former Freeport employee. From what I recall, he just stated he was an engineer and that he was this the one that was currently in Albuquerque and pursuing a medical degree or something like that?
Yes, that was
Okay.
the public commenter. Yes, well, I'll represent to you that he was a prior Freeport employee.
Okay.
If you had attended the hearing, you would have been aware of all of the testimony provided by the department witnesses over 2.5 days regarding the very issues that your opinions in your written testimony and oral testimony reflections on, right?
Objection, misstates the testimony. He testified that he appeared for parts of it and watched online for parts of it.
Yeah.
I'll rephrase that had you attended the full hearing, as the board members have, then you would have been aware of the testimony addressing many of the facts in your testimony, correct?
Objection, relevance.
Yeah, I don't know that this is especially helpful, Ms. Sona.
Well, Madam Hearing Officer, my point is that we're not dealing with credible evidence, and I'm entitled to cross-examine on credibility. And a witness that has failed to avail himself of opportunities to educate about the factual and misfactual aspects of his testimony. My plan was to address this rather than go through many of the details. But if you'd like me to move on, I'll surely move on to the very specific points of all of it.
Okay, so obviously more limited participation perhaps goes to the weight of the statements made by Mr. Sonnenberg than full participation. I think you've already drawn out his acknowledgement of limited participation. I'm wondering if you have other areas of questioning as to the substance of his statements.
I do. I have many, Madam Hearing Officer. Mr. Sonnenberg, did you contribute to a 2022 article entitled Transboundary Transport of Ozone Pollution to a U.S. Border Region, a case study of Yuma, through conducting investigation, gathering and analyzing data, and writing and reviewing and editing the article?
Yes.
I'm going to read to you the first two sentences of the article and ask if you recall them. Air pollution poses tremendous challenges to human health, ecosystems, and food security. Each year, about 4.2 million premature deaths are linked to ambient air pollution globally. Do you recall writing that or that being a part of your article?
I object on the grounds of relevance and outside the scope of his testimony. I don't think that Mr. Sonnenberg raises any questions regarding analysis of health effects of air emissions or anything of that sort, and I don't know why that's relevant to this matter.
I'm trying to very carefully lay a foundation to get to my point. If you want me to just skip the foundation, I'll just ask my question. But
yeah, tell me how you're going to tie this into what he did testify to.
So the next point that he makes in his testimony or in his article is specifically regarding how all of his work is for modeling, data collection, and analysis, and ongoing monitoring. And this goes directly to his testimony to say that those are not appropriate costs for the department. So
I would just cut to the chase there.
Mr. Sonnenberg, based on your experience as a regulator, activities such as modeling, data collection, and analysis, and ongoing monitoring require staff, resources, and technical support and are core aspects of air quality programs, correct?
Yeah, I believe what you're describing is Title I programs under the Clean Air Act.
I'm describing what an air quality program does, talking about modeling, data collection, analysis, and ongoing monitoring. Those are core components of an air quality program, correct?
Yeah, I would say so.
Right. A couple of my questions were covered by Ms. O'Grady, so I want to make sure I don't repeat them.
Thank you.
Let's see. So you shared with us in your oral summary some of your perspective about the annual review or periodic review that mining is asking for inclusion in the bill. Do you recall?
Yes.
Okay. You're aware that the department opposes mining's proposal to tie the consumer price index to presentation of that review to the board, correct?
Sorry, do you mean the department opposes that tying the Title V? Is that what you said?
Yes.
Yes. Yes, I'm aware.
Okay. And given your experience with Title V, you're aware that the Clean Air Act requires state air pollution control agencies that administer their own programs, like New Mexico, to shall impose yearly CPI adjustments, right?
So I'm actually not sure on that. What I am sure is that EPA does audits or reviews of Title V programs, and during that time they evaluate whether the fee is adequate to fund the program, and they have presumptive minimums. There may be a provision in there that requires Title V to be indexed to inflation. The presumptive minimum is definitely indexed to inflation. Also, EPA runs its own Title V program, and the fees for the EPA Title V program are indexed to inflation. So if you're saying there is a requirement that Title V is indexed to inflation, that may be true.
So I'll represent to you that that is
Okay.
in section 7661A, which the board has it in their exhibits, subsection B3B. With that representation, if the board were to include mining's proposed revision in the rule, the practical effect of that is that regulated sources would gain an incentive to challenge, delay, or weaponize a process that is what is intended to be just a ministerial adjustment or a cost increase into something that becomes more discretionary and contingent, correct?
I don't see how industry would weaponize the requirement for the department to provide an annual report. Maybe you can help me understand. Yeah, go ahead.
Sorry, I thought you were done. So regulated sources, they have a financial interest in minimizing fees, just kind of across the board, right?
I'm not sure I would go that far, actually. I mean, what's really important to us as a regulated community is that we have reasonable fees, but more importantly, that we have consistent and fair application of the laws. So, you know, and I talk a little bit about this in my testimony. The presumptive minimum that the Chino and Tyrone mine would pay if EPA were to take over the Title V program, if New Mexico were to abandon the Title V program, program would revert to EPA. We would pay the EPA fees for the EPA program, and that would be much less than New Mexico's program. But that's not what we're advocating for. Sorry, I'll slow down. We're not simply seeking to minimize fees to the extent possible.
So I don't think you really answered my question, but what I heard you say was that an example of what industry is looking at in this scenario is that EPA would have lower fees. So my ask is that the contingency that you are asking this board to adopt is that a fee increase tied to the CPI depends on a procedural step. And that step is very relevant to ultimately what regulated sources pay, correct?
Okay, so if I could just restate to make sure I understand. So what you're saying is that the procedural step to provide an annual report influences whether the department does that or not, influences how much regulated sources pay. Is that
yes, that's
yeah?
the exact
Okay.
practical effect of what the mining's proposal would do. And so I'm asking, do you understand that that's the effect?
Yes, yes, I do.
Okay. And so if there's circumstances beyond the department's control that could potentially delay that annual review being delivered to the board, under that scenario, the CPI adjustment would not take effect, correct?
Correct.
And that would result with fees not keeping pace with the CPI adjustment.
Unless and until the department finally did provide that report.
And as you agreed with me a few minutes ago, this CPI adjustment is a requirement in the Clean Air Act. When you indicated that you understood my representation, that that's what it requires. So that the logical conclusion from that understanding is then that the department would not be complying with the Clean Air Act, correct?
With that representation, yes, I agree with you. That would be unlawful, or excuse me, I'm not an attorney. I can't make that statement.
So moving to some of the more specific language in Title V, you're aware that particulate matter has long been regulated as PM10 and PM25, which are the more conservative indicators of particulate matter with respect to health protection than a TSP, correct?
Yes.
Okay. And you're aware TSP is no longer a regulated pollutant in New Mexico?
Yes.
And you're also aware that New Mexico permits no longer have a line item for TSP emissions, but only include PM10 and PM2.5, correct?
Yes.
So is it your position that regulated sources can continue to emit particulate matter 10 and 2.5 when they don't have to pay emission fees for those pollutants under your proposal?
Well, continue to emit is kind of tricky because, you know, as we've discussed a lot, you know, it's based on allowable emissions and not on actual emissions. So it really has nothing to do with the actual emission rate. But I think the larger point you're trying to make is under the proposal, fees are not tied to allowable emissions for particulate matter. That's correct.
So your proposal is for this board to keep a fee structure for a pollutant that's no longer regulated at the federal or state level?
Yeah, our position is not so much based on some philosophical argument about whether or not particulate should be a fee pollutant or not, but just that action would have the effect of raising fees. And for a fund that has $7 million in it and has not, you know, kind of fee spending has not increased above revenues for more than 1 year, that you know, any action to raise fees just seems premature at this time.
So I'm not sure that actually answered my question, but okay. I guess I'll move on. I think the plain language of the rule speaks for itself. The language that mining struck in section 111A9, which is page 3, lines 1 through 4 of your exhibit. I apologize, I don't remember the number, but it's the Title V rule. You're aware that this has been language in the rule since 2004, right? And perhaps
Yeah,
I can give you better context.
I have it right here. I'm reading it. I don't think I was aware of that.
With my representation to you,
Yes.
the language, the department just moved it from one position provision to another to align with the state records request for how rules are written. Does mining no longer have any opposition to that, and it's fine keeping that in the rule?
Yeah, with that representation, I would agree with that.
Okay.
Would you please clarify your reference?
Yes.
The red line was in exhibit 7 is part 71. And then exhibit 8 is part 75. So where were you?
We're in part 71 for the Title V emission fees. And I believe my notes say page 3, lines 1 through 4. And Mr. Sonnenberg's nodding that that's should be where the board can find that that's no longer mining's position to strike that language.
Okay, thank you.
Okay, turning to our other set of fees, the construction fees in part 75. Mining's proposal included the same application point increases that the department is proposing to the board, correct?
Yes, that's correct. I thought we reverted those, but yes, that's correct. That's the copy I have in front of me.
Can you clarify then what your position is? Is mining asking, they're saying they agree with the department and those point increases are the appropriate path forward, or are you saying that mining opposes them and just didn't put it
yeah, thank you. So our position was that, you know, we would oppose the increases here for those number of points. We did agree with the department to add the late fees for sources that didn't pay on time. And I think we agreed with the department on a few other things, but I think our proposal was to oppose the increase in points, or our intention was to oppose the increase in points.
Okay. Well, that makes it a little confusing for us, but I
understand.
Hopefully that tracks, I guess. The way that does that mean you also retract your testimony on page 14, lines 6 through 7, that reads, overall, the proposal would result in either no change or only a modest increase in most construction permit fees. Although the fee amounts listed in the rule appear higher than current figures, these increases largely reflect annual inflation adjustments that already occur under existing regulations. Let me first ask you, did I read that correctly or represent it?
I couldn't find it, but it sounds familiar.
Okay, so this is your testimony that I got confused about, where your rule said one thing, your testimony actually says two different things. So mining is opposing the nominal increases to construction fees.
Right. Yes. What I meant by nominal increases is that I was looking at the fee per point. You know, that was like increasing to 585. and I can't remember what it is currently, but it's something like 560. And so that's what I meant by nominal increase.
Were you here, or I'm not trying to go against your order to move on, I'm just trying to set foundation. Were you here or listening to the hearing, or was it represented to you afterwards that the department has testified about how if this fee increase doesn't happen in less than 3 months, they're going to have to take some pretty drastic measures to start reducing costs and reducing workload?
I've heard testimony to that effect, yes.
Okay. As a former regulator, do you oppose the department stopping support from contractors who help with the backlogs for reviewing minor source permit applications?
No, I don't oppose it. And I'd like to kind of expand on my answer. Sorry, I'm getting confused a little bit, but sorry, can you restate the question?
Sure, no problem. So this is what I stated. It was, as a former regulator yourself, do you oppose the department stopping support from contractors who help with backlogs for reviewing minor source permit applications?
Okay, yeah, I got that. Can you, and then the question before that was, because I think that set the foundation, and that's
the question before that, which you agreed to, and counsel, please correct me if you think I'm mischaracterizing his testimony. My takeaway was that you had heard testimony from the department about how drastic cost measures would have to be implemented and workload reductions.
Okay. Yeah, that's sorry. That's the thing I wanted to go back and to address. So I did agree with that. I did hear that testimony. I think that testimony is a little misleading in the aspect that a lot of the statements made by the Environment Department are like, we're going to have to take drastic measures, we're going to have to cut programs. The projections represented by Mr. Polgar, at least as I understand them, are talking about an expansion of the program. So he's adding 80 people or 81 people, FTEs to the budget and $8 million, and saying we're going to run out of money or we're going to have to make drastic changes. Those 80 people and that $8 million is not being spent today. And so that's not really like a difficult decision that like they're going to have to let go people or cancel contracts or things like that. It's simply they're not going to be able to expand or be able to create those positions. They're not going to be able to sign new contracts. So no, I don't support, I mean, I don't want to see any canceling of existing contracts. But I don't think that those existing contracts are the reason that that the department is projecting such big decreases in fund balance.
Are you aware that the department, in addition to providing forward-looking projections about where the needs of the program need to be, also provided to the board what they called a business as usual scenario? Are you aware of that?
Yes, I am.
Okay, and so does your testimony remain the same given what was presented regarding the business as usual scenario, that even if fees are not increased and we continue, the department is still going to have to take cost-cutting measures to address the fact of the fund balances?
I'll just object to the form. That was confusing to me. If the witness understands it, that's fine.
Mr. Mullenberg, Mr. Sonnenberg, did you follow that?
I think so. So yes, I do recall that the department presented a business as usual scenario. And I do recall that that shows, yes, that there is a fund imbalance.
Do you agree that the mining association's members benefit from timely permit issuance?
Yes.
Do you agree that they benefit from predictable regulatory processes?
I agree. Yes.
And I think you said this before, but just for context, you agree that you also benefit from avoiding federal intervention in the air quality program, correct?
I don't know if I would use the word benefit there, but I think it's something that we want to see. We want to see, you know, New Mexico retain control of its own air quality program. Yeah.
And as a former regulator, you agree that providing those types of benefits requires a fully funded permitting program, right?
Object to the form in terms of those types of benefits. I'm not quite sure what that meant, but if the witness understands, that's fine.
Yeah, go ahead if you have an answer, Mr. Sonnenberg.
Yeah, I think I agree. I think we have a disagreement of what fully funded means here, but yes, in general, yes.
Okay. Real briefly, since you mentioned it a few times, the EPA's presumptive minimum, if we could turn to that. You're aware of how that works? I take it.
Yeah.
Okay. And so you're aware that EPA's presumptive minimum is based on and used by programs that assess emission fees based on actual emissions, right? And you're aware that New Mexico's fees are based on allowable emissions.
That's correct.
Right. Right. And some of the testimony you provided was about Freeport mines in Arizona and their Title V emission fees. Do you recall that?
Yes, I do.
And it's true that Arizona assesses fees based on actuals, correct?
So, not completely. And there's a little bit of a apples to oranges problem here. So, Arizona has a unitary permit program. So in Arizona, there are not separate NSR and Title V permits. And what you're talking about, so as far as fees go, which fees go to support both programs, there is a fee that is associated with allowable emissions, or excuse me, actual emissions. I think that's about $20 per ton or something like that. Anyway, so what the fee program looks like is that there is a flat fee, and that is the main part of the fee. The fee is set by industry. So, for example, mines pay a certain fee, smelters pay a certain fee, and power plants pay a certain fee, and so on. That is the main part of the fee. For some sources, there is an additional fee that is based on emissions. In addition to that, and that's the allowable, or excuse me, I keep saying allowable. That is the fee for actual emissions.
Okay, so it sounds like Arizona's structure for fees is very different than New Mexico's structure for fees.
That is correct. Yes.
Okay. So if we're talking apples and oranges, to use your analogy, for New Mexico and Arizona, it's not really helpful for this board to consider what Freeport pays for Title V in Arizona, correct? Because it's a different regulatory structure.
So I think it I think it's relevant in the sense that the requirements that the programs are trying to fulfill, you know, you talked earlier about like, what are the elements of an air quality program? You know, there's permitting, there's monitoring, there's other things. Those fees support some of those activities. And so I think it's just helpful as a guide that that the board understands that what the fee structure is in other states and what comparable sources would pay in other states, to kind of level set on like what the program support would look like.
Mr. Sonnenberg, you're aware that the regulated source makeup in New Mexico is vastly different than what it looks like in Arizona, right?
I would agree with that statement, yeah.
Okay. So again, we're back to apples and oranges. It's not comparable to say the needs of the Arizona program are the needs of New Mexico's program.
Objection argumentative.
Yeah, I think he's already answered, Ms. Sona. And let me ask you, are you going to be able to wrap up in the next 7 minutes or so?
I'm going to try. I have maybe 1 or 2 more issues to try and get through.
Okay.
And respectfully, my question was a tiny bit different, so he hadn't answered that one yet.
Okay, please move on.
Mr. Sonnenberg, you shared with us your resume that states that you, as a former regulator, were involved in the budgeting process for Arizona. Is that correct?
Yeah, that's correct.
Okay. And in your experience with that and with budgets and accounting for state government programs, state governments typically have internal controls that govern how they're spending their funds, correct?
Yes.
Are you aware that New Mexico's programs have such internal controls and sub-accounts for the special revenue funds that govern how those funds are used?
Yes, I am.
Are you aware that those specific controls allow the air quality program, with its 2 different bureaus now, to clearly differentiate and track the air quality program's financial activities?
Yeah, and I think the point that you're referring to in my testimony, the point I was trying to make is that it wasn't transparent to us. It wasn't transparent to the mining association how those funds were being spent. I'm sure there's some kind of internal process or controls. When we look at the state auditors reports, what we see is very confusing because it has revenue associated with the special revenue fund, and then the special revenue fund does not log any expenses. Instead, it just says like transfer out to the general NMED fund. And so we have some concern about the transparency that we're not able to show, or we're not able to see what activities are being charged to that fund. We can only see expenses on an agency-wide level. So I agree with you. New Mexico probably has some internal controls, and maybe there's some internal reports or something like that. But viewing the state auditors reports, we were not able to see that, and that's what I was testifying to.
And I thought I understood when you were speaking with Ms. O'Grady about the auditor reports that those were perhaps not the right type of documentation to be seeking the information that you are stating is missing from those. Did I misunderstand that agreement that you had with her questions?
That I said, sorry, that I agreed with her that the state auditor's reports were not the right reports to evaluate the program.
Correct.
So I'm actually not completely sure what I said. I think what I was kind of getting to, and I'm glad we looped back around to this. You know, the line of questioning that we could have filed like a public records request or something like that. That would only, you know, those kind of public records would only be for historical data. And really what we were looking for when we met a couple of months ago and to kind of evaluate the program was that future looking data. And I'm not sure that that would have been good or that would have been subject to a public records request. Yeah. So yes, I believe I agreed with her, and I will agree with you now that when it comes to setting fees, having forward-looking data and projections is a lot more helpful than looking at historical data. We looked at historical data because it was the only data we had.
Okay, and so do you agree that it's good for the board to be considering these forward-looking projections that the department's presented? And that's, let me rephrase that because I think I was going to make that confusing. So you agree that these forward-looking projections are more helpful for the board than for them to really consider and look at the backward-looking data that you provided in testimony?
Yeah.
Okay.
Can you wrap up?
Yep.
Okay.
I apologize. This line has some crossover from Ms. O'Grady, so I just want to make sure I don't ask the same questions. Is it your position, Mr. Sonnenberg, that this fee alignment proposed by the department is going to have significant financial consequences for members of the mining association?
Can you repeat the question?
Is it your position that the fee proposal to align fees that the department's presented would have significant financial consequences for members of the mining association?
Yeah, I think it depends on your definition of significant, but yeah, I'll agree with that.
Okay. For Freeport, they are a publicly traded company, correct?
That's correct.
And they file 10K disclosures regarding their publicly traded stock, in which they disclose when a regulatory program's decisions could cause loss for a company to the shareholders, right?
I am not familiar with that process, but I'll take that as true. Yes.
Okay. If I represent to you that this rulemaking has not been disclosed by Freeport as something of significance to its shareholders, does that change your opinion about what is or isn't a significant financial consequence?
I don't know the law in that arena, and has been said before, I'm not a lawyer. I'm not saying significant in any legal sense, and definitely not within the meaning of the Security and Exchange Act. Yeah, I suppose that's my answer. I don't know what significant means in that regard.
So does this rulemaking have an impact on mining association members when the increase for one of the fees that they're opposing is only about $250 a year.
Objection. Asked and answered.
This hasn't been answered. Actually, Madam Hearing Officer, it's a different question.
So you asked if there was going to be a significant impact. You said yes, depending on your definition of significant.
And I provided some context for what could define that. And then I'm providing another context for what could define significant.
Okay, and then are we?
And then we're done.
And then we're done. All right.
Depending on his answer, you know, the lawyer always, but yeah.
So, sorry, can you ask the question one more time?
Yeah, let me see if I can remember it. So we talked about significant in one context for Freeport. I'm asking about significant in the other context, which is one of the fee adjustments that the department is proposing amounts to about $250 a year. Is that a significant financial consequence to the members of the mining association?
So what is this fee that's increasing to $250 per year?
It's one of the annual fees in the construction permits rule.
So 250, I'm not as familiar with that. I don't think Freeport pays the construction permit annual fees because we pay Title V fees. But yeah, if there's an increase of $250, I guess I would agree with you that that's not significant.
That is all of my questions. Thank you very much, Mr. Sonnenberg. I appreciate your patience as I worked through this.
All right. Thank you, Ms. Sona. Mr. Mullenberg, I'll ask if you have redirect after we come back from lunch. Let's come back at 1:05, please. We are back after a lunch break. When we broke, the other parties had completed their questioning of Mr. Sonnenberg. Mr. Mullenberg, do you have redirect?
Thank you, Madam Hearing Officer. A few questions for clarity. Mr. Sonnenberg, do you recall being asked a question about whether certain monitoring activities or other types of things were a core part of an air quality program?
Yes, I do.
Do you have anything to add to your responses on that regarding particularly the meaning of an air quality program?
Yeah, I think the definition of an air quality program can be kind of fuzzy. And, you know, as I alluded to, there's Title I and Title V under the Clean Air Act, and those cover different activities. And I think it's important to kind of think about those activities separately and the funding for those activities separately.
Thank you, Mr. Sonnenberg. Do you also recall a question in your answer as it pertained to the Arizona Title V fees? I believe they were, and their relevance to this proceeding?
Yes, I do.
Do you have any further things to say about that as it relates to the hearing and things like fee equity?
Yeah, I think, you know, the department has raised kind of the idea of fee equity and making sure that fees are equitable. And so I think, you know, I further expand and say that, you know, I think it is permissible or maybe I shouldn't use permissible, maybe that's a legal thing, but I think it is useful for the board to look at other states and what comparable sources would pay in other states. That's not to copy exactly. Of course, New Mexico has its own program, its own unique mix of sources, its own policy decisions to make. But thinking about those things, I think looking at other states can be one element of that.
Thank you, Mr. Sonnenberg. And on another topic, do you recall being asked a question and giving an answer on the department's business as usual scenario?
Yes, I do.
And what is your understanding of that business as usual scenario in the context of projections versus, say, current spending?
Sure, yeah. So my understanding of the business as usual scenario is that it is not simply carrying current spending levels forward, but it does continue to add that $8 million in contractor spend going forward. For comparison, what NMAD has presented is that in fiscal year 25, they spent about $2.5 or $3 million in contractor spend. The year before that, I believe, was much less. So this would be, at least an increase over the fiscal year 2025 spending levels of about $5 million for the business as usual scenario.
Thank you. And just finally, thinking about your written testimony and the questions you were asked and the answers you gave today, do you have anything else that you'd like to clarify or any final thoughts to leave for the board?
No, I don't think so.
Okay. Thank you, Madam Hearing Officer. Thank you, Mr. Sonnenberg.
Thank you, Mr. Mullenberg. I will turn now to Ms. Sona. Do I see your finger hovering? All right. We'll turn now to board questions of Mr. Sonnenberg. Member Curry, would you like to kick us off?
Sure, thank you. Just one question on your charts in your visual display. Both your Title V fund and your construction permit fund would indicate that the fund balance is dropping on the Title V, or is leveled out on the, is dropping on the Title V and is leveled out on the permit fund, and the revenues are increasing, and we're also suggesting the transfers out are increasing. So are you implying that if the legislature were to allow the department to move that money into the permits for 27, that would be fine? Or are you implying that if that was true, then after 27, they would be X'd out as far as funding goes, if you use that fund balance? Am I reading that incorrectly?
I'm not sure, but I'll maybe explain. So transfers out is the language that's used in the state auditor's report where we got this information from. I assume that means expenses for the fund. I do see that the fund balance for the construction permit fund has leveled off in the past year. And for the Title V fund, there has been a slight decrease. So I agree with you there, but help me out again with the question.
Well, if the trends continue there, it would imply to me that if the legislature let the department use the revenues as they went up and the fund balances as they went down for the program, proposed program, that it might suffice for 27, but after that, what happens?
I think I haven't done the math on that, but yeah, if current spending levels continue, I think, or if they increase, there will be a need to increase fees at some point. But I think the point that we're trying to make is like there's not this dire cliff that's out there, and really the department should spend down these funds if they do need to have these additional programs, avoid the potential for a fund sweep by the legislature of that $19 million. And then, we can talk about increasing fees in kind of in an equitable way. So, and I think one of the exhibits presented by the department showed that, their position creation strategy or something over the next 5 years. I believe for fiscal year 27, which is the one coming up, they were proposing to create 0 new positions for fiscal year 27. So of course, I don't know what fiscal year 26 spending levels are, but I don't think we're going to see this kind of huge increase in spending.
Okay, thank you. It's very vague that what you're saying is there's a lot of decisions that would fall into the hands of the legislature.
Sorry, what was the second part of that? There's a lot of decisions in the hands of the legislature, but
they have to go through the LFC and the DFA to move those either in the budget or BAR after. It just, I just, what I wanted was what you saw as the trend, and you've answered it. Thank you.
Okay.
Thank you. Member Garcia.
Thank you. Just one clarifying question on your proposal for the fee changes in part, or the language changes in part 75, construction permit fees and Title V. I understand your changes in terms of you don't want the fees to go up quite so much in some instances, and a few other changes are fairly clear to me. But one question I have, I understand you want to have the periodic review, not only in part 75, but also part 71. And you put language in for having the review presented to the board. And I'm looking at
and
okay.
Yeah.
Put language in to have the review presented to the board within 6 months following the end of the fiscal year. I did hear at least one person from NMAC, I think it was Mr. Polgar, said that they would be willing to throw in the Title V information along with that report. So I believe they're willing to give us a report, an annual report. How critical is it that it's within 6 months of the fiscal year to you all?
I don't know how critical it is. I will say this, that that aligns the deadline of the report with the end of the calendar year. So the fiscal year ends in the middle of the year. And so, and also, at least from my review, looking at the state auditor's reports, that aligns with the cadence of the state auditor's reports and when they come out. As far as criticality, I think it is important that they be timely. But, I also know that the department has a big job and there's a lot there. So I thought, 6 months made sense, but if the board wants to put in some other number in there, then that's totally within your power, and I would be okay with that.
Okay,
Yep.
that's all. Thank you.
Thank you, Chair Ely. A few questions. And thank you for being here today, and thank you for your testimony.
Yeah. Thank you, Cherry.
I think it's on page 11 of your written testimony. You mentioned the cost of about $500,000. Am I reading that right?
Yes.
Under the proposal, Title V permit fees would increase to approximately $500,000 per mine. Now, in developing that number, does that account for the 30,000 or 3,000 TPY cap?
Yes, it does.
Okay.
So I think I don't think the Tyrone mine has any pollutants that are over the 3,000 ton cap. I think the Chino mine has about 4,000 tons of allowable emissions for particulate. And so it does decrease it. I think, the proposal we looked at in 2024, we were around 520,000 we were looking at for that mine. And this has dropped it to somewhere closer to 400,000, but I still rounded to, you know, around 500K.
And then I believe I remember correctly, the TSP came off the books, was removed from regulation in 2019. You remember what, say, Tyrone paid prior to that date, or any other of the mines you're familiar with?
No, I'm not. I was not working at Freeport then. I'm sure that's something you guys can look into.
Yeah, just curious because how it compares.
Sure.
Now, and then looking back at, and I asked that question, I believe 2 years ago, and I didn't get an answer then either. So, but I also didn't go ask the department to provide that information. I'm looking at the markup that you provided, and that's your Exhibit 7. And I just want to make sure I understand what you're doing here. I missed, or wasn't tracking some of the cross-examination with Council Sona, and this may have been addressed. I just wasn't clear to me. So under 71.7, under definitions, there's a definition of fee pollutant in paragraph C. Are you proposing adding total suspended particulate matter back in? That's kind of what it looks like.
Yeah. So what we did there was just revert the change. I get what you're saying. It is confusing because that would still have the impact of no fees for total suspended particulate. So, you know, I kind of explained this before, but I think our opposition there is just that it would have the effect of raising fees, and we see that the fund seems pretty healthy to us, at least looking at historical data.
So you're proposing to not pay any fees for particulate matter under Part 7?
Yeah, that would be the impact of it. Again, not that we're opposed to paying fees for particulate matter, but just that it would have the impact of raising fees for a fund that is already bringing in more than they're spending.
And I think I do remember testimony from Bureau Chief Hollenberg that they may have missed out on $2.5 million over the last several years since TSP was rescinded.
I do remember that testimony, yeah.
I just don't know how it applies to Tyrone.
Yeah, I don't know how it applies to, I don't know how it's divided between those, or I can't remember if that was statewide or just for those two mines. I can't remember. Okay, yeah.
Okay. And so I'm going to walk through some of this markup, just to make sure I'm clear. So when we go into deliberation, I know what we're talking about.
Absolutely, I appreciate it.
Okay. And then under 71.111, fee determination, striking paragraph 8 is consistent with striking PM10 and 2.5 above. So I think I understand what you're trying to do there. And then I heard, I believe correctly, your conversation with Ms. Sona about 9, that maybe, you know, that's been in the rule for over 20 years. Maybe you want to keep that in the rule?
Yeah, I think what she said is they moved that from somewhere else in the rule. And so we reverted it. But if it's something that's already existed in the rule, I don't think we have any opposition.
And then 112 on emission fees, could you explain that markup? Are you proposing $20 a ton plus the $2 at keeping the $2 per ton increase?
So this falls into the category of reverting back to the old language.
Right.
So you see, you have to take that paragraph A in conjunction with paragraph D. So what the Environment Department did was they proposed raising it to 80, and then in paragraph D, they moved the inflator baseline to 2028. And what we did is we moved the inflator back to 2009, and the base of the inflator back to $20 per ton, which would have the impact of keeping the fee at $40 and whatever cents per ton. Yeah.
So, all right. I think I understand that. And then under 113, you're striking paragraph D, which also may be something that's been in the rule for a while. So.
No, so that's actually something that the department has removed from their proposal.
Oh,
that's the recovery of the administrative costs.
Oh, got it. That's right. So maybe I should back up a little bit. This is a markup of what the department submitted with their NOI.
Right.
Correct. Right. And then the annual review language that we just discussed.
Yes.
All right. So, can I go to 8?
Yep.
Exhibit 8. Again, just to make sure I'm clear what your intentions are here. I see and noted no markup on the number of points for NSR permits.
So we did discuss that. I think and we can maybe provide an updated version, but we were proposing to, our intention was to propose reverting the points, which again is not a huge change. The modeling review points, I think, went from 10 to 30 or 15 to 30. The changes for oil and gas facilities don't really apply to us, so we were proposing to revert those, but honestly, we could go either way. And I think those were, and the notices of intent, again, that doesn't apply to any mining association members. So, so I guess it would really just be reverting the modeling review points.
Okay. And then the cost per point at 315 is what you're proposing.
Right, which again is on that 2009 or 2003 baseline. So it's like 560 something now.
Okay. And then could you explain paragraph F? Your changes there?
Yeah, I think that is another reversion of the fee increase. This is about fees for so there's a couple of things here. Sources filing a notice of intent have to pay $700. The construction permit fee, or excuse me, the annual fee for construction permits being changed to $2,800. So again, but this all falls in the category of reverting to the old language.
Okay. And then I do recall the discussion on G. No increase in any fee shall take effect until the department delivers the report to the board. And then below in 75.12K, we department took that out.
Correct.
And then periodic review. Okay. That's all from my questions right now. Thank you. That was very helpful.
Thank you. Let's see, Vice Chair Sweeney. I'm not sure. I know you're on the platform, probably on the phone. Can you unmute yourself and do you have questions? All right. Member Bitzer, do you have questions?
I did, but they got answered, so thank you.
Thank you. And we don't have Member Carrasco, right? That's correct. Okay. Anything else at all from the board? No? Well, thank you very much, Mr. Simon.
All right, thank you.
I don't believe there's any more technical or non-technical testimony or comment to be offered. So, Madam Chair, I would, sorry, Sona.
I'm not sure, I didn't ask, council, but the department does have the numbers that, Chair Ely was asking for. If she wants them, I'm happy to provide them, but as long as you're okay.
Yeah, if you have numbers and can identify the source. I take it that was the numbers that she was just asking Mr. Sonnenberg about.
Yes.
Okay.
Go ahead, Ms. Sim.
Yes, so the numbers we pulled, Chair Ely, they're from the permits and then the calculation for the fee at that year. So in 2018, which was the last year for collection of particular fees, the Tyrone mine paid $184,620 for particulate emission fees, and the Chino mine paid the same amount for emission fees. And this was because they both had allowables above the 6,000 ton cap, is the note by staff.
All right, thank you, Ms. Sona. Is there any reason not to close the evidentiary record at this point, such that the gavel would be passed to the chair to talk about whether they wanted to hear closing argument, either orally? I know you submitted yours in writing already, Mr. Mullenberg, and whether they wanted, when they want to deliberate. Any reason not to close the record? Nope. Thank you all very much. The record is closed, Madam Chair.
Yeah, so I do have a question to the board. We can, and on a date on when we do want to deliberate, it's possible we could deliberate this afternoon if you're feeling clear about what it has been presented. I just text Vice Chair Sweeney. She wants, yeah, she also said her preference is to deliberate in the future. Okay, so, all right, so we won't deliberate this afternoon. That'll give us a little more time to look at the record and think about what's being proposed. We do our next meeting is April 13th, is that right? We have a 3-day hearing set beginning on April 13th for EIB 25-81 related to PFAS and aqueous film forming foam and hazardous waste fees. I don't believe that hearing will take 3 days. One option is to do the deliberation of this rule at the beginning of that hearing on April 13th. I think we can get through the deliberation in a couple of hours at the most. That's one option. I'm just wondering if the board has any, want to have any discussion on that. I'd like to hear how you feel about that.
Chair, this is Vice Chair. I'm open on the 13th, and I support that.
Was that Member Carrasco?
No, this is Member Sweeney.
Oh, I'm sorry. You sound like The Exorcist.
Oh
okay.
no,
but
sorry.
I heard it. I heard it. All right.
Yeah, I apologize.
That works. April 13th at the beginning of before the other hearing starts. That works.
Member Curry, I see you're nodding yes. Member Bitzer, do you have an opinion on that?
I'm trying to bounce to my April 13 through, yeah, it looks like I blocked out the whole week. 13th through the 17th. Are we really only scheduled for 3 days?
It's funny because I blocked out the whole week too, but I don't think we are.
No,
Okay.
we have an NOI only from the department, and the only other entry of appearance we have is from Mr. Weatherby.
So yeah, I can do that week, or certainly the first 3 days of it.
Member Carrasco, are you online? He's not. Okay. Well, we've got 5 of the current board members in agreement to deliberate on the 13th. So I think we should take advantage of that. As I noted earlier, I don't think it'll take too long to go through these deliberations, and with only an NOI from the department on AFFF, I think we're good. We'll have plenty of time for that.
So, Madam Chair, I think one question you might want to answer is whether you'd like to invite written closing argument from the department. They did prepare, and I know some of the board members have already studied it, the statement of reasons. You might just want to talk about the possibility of closing argument.
Yeah. The statement of reasons is very complete. I don't think it would take at least the department very long to prepare closing arguments. Mr. Mullenberg, do you have an opinion on how we should proceed on that?
Thank you, Madam Chair. As you know, we did submit a written closing argument and legal brief in anticipation that the board might go straight to deliberations. Obviously, we did that without the benefit of the record. I'm not sure if there's anything we need to change on that, and I'm not sure when we might have a transcript to check to see if we have anything to add to it. I mean, I'd be happy to hear what the department thinks, but I guess the only thing I would ask for is, having the benefit of a little more time and perhaps a transcript if there is anything in there that we would need to update or fix to reflect the specific record. That might be useful, and I can't tell you for sure if we'll even get to that.
Ms. Sonal?
Thank you, Madam Chair. The department would definitely appreciate the opportunity to similarly file a closing argument just to tie together the many perspectives that we've heard throughout the past couple of days. We'd also appreciate the opportunity to respond to the legal brief that has been filed. Usually we get those much more in advance, and so for the benefit of the record, Madam Chair, I'm hoping that the record could remain open for that specific filing, given it is sort of a record matter rather than a closing matter. And I don't foresee that we would have any changes to our proposed statement of reasons. I will certainly take a look at that and provide that in redline form to the board so they can easily identify if there are matters that have come up during the past few days that would change what we feel is appropriate for the statement of reasons. The last thing that I would add is that in looking at what publication of the rule is like with the dates for the state records and all of that, it would be most beneficial to get the signed statement of reasons and the signed transmittal form if the board is adopting the rule by April 17th. So I don't know if that can be part of the deliberations and specifically going through those conversations on the 13th. Particularly given our hearing officer will be in hearing the next few days for that. Just flagging that April 17th date is our goal date to be able to really get everything signed and communicate that over. I think I covered it.
Just to respond there to Ms. Summer's last point, it's always helpful when the petitioner identifies the deadline they're confronting in order to reach publication. April 17th should not be an issue if the board does adopt the rule on April 13th, because the final motion ideally would have three parts. You adopt some form of the rule. You authorize the petitioner to work with the Record Center around formatting, and you authorize the chair to sign the SOR. And that way the board doesn't have to meet again to adopt the SOR.
And also just to clarify, Ms. Sona, so if we have a signed SOR in transmittal form by April 17th, you will meet the publication date for archives and then an effective date of June 1.
Correct.
Okay. Yeah, okay. I think we can do that. So I just, Mr. Mullenberg, I think you were suggesting more time than we would be considering if we had a deliberation on April 13th. I'm wondering if you could live with a time frame in which we get the final closing arguments, say by the end of the day, April 9th, so the board can review it on the 10th and over the weekend and then deliberate on the 13th. Was that doable?
Yeah, I think that's fine. Again, I think from from our perspective, we'll just want to, with the benefit of a little more time, look back at the record if we have a transcript and either replace, supplement, or correct the written closing argument that we filed. So I think, yeah, we can live with that. I guess my only other comment is in response to Ms. Kelsey's suggestion of a response to the brief. It is, in my experience, the normal practice that we typically file closing arguments with legal arguments after we get the record. Here we're doing it before, but we don't normally have actual responses to closing arguments and final legal briefs. So I would just comment on that would be a little different practice. There may be some old rulemakings where we did it that way, but it's been a while. And there's not a lot of time to.
I'm usually very expansive in my understanding of what argument is invited as part of the post hearing submittal. So I don't think it's an issue for any party to include any legal argument they'd like the board to consider.
The only other question I have is oral closing arguments.
It sounds as though you already have industry's written closing. Ms. Sona has committed to providing the petitioner's written closing. Typically, when you have written closing, we don't also have oral closing.
All right. So I think we're good to go for deliberations on the 13th with written closing arguments submitted to the department by the end of the day on Thursday, April 9th, and no closing oral arguments.
Madam Chair, if I may.
Yes.
Can you clarify for us, end of day, sometimes close of business means 5, end of day sometimes means midnight. Can you confirm exactly what time maybe, just so we're all on the same page?
I'm going to say 5 p.m. so that Ms. Jones can get it out to the members of the board right after that. So we have as much lead time as possible for us to read it.
Okay. I will endeavor to file the departments early so you have time.
Okay. Thank you. Yeah. All right. So we're back on the agenda, right? Yeah.
Absolutely.
Yeah. So the next item on the agenda, now that we've taken care of agenda item number 5.
Can we excuse Mr. Lee?
Yes, Mr. Lee, thank you so much for your service. We look forward to seeing you on April 13th. Yeah. So the next meeting, as noted, we had our monthly meeting now, So we don't have to meet again on Friday. Our next hearing and meeting date, or next date to gather, is on April 13th. I want to note that the technical testimony, the NOI, as noted by Hearing Officer Orth, was submitted this week. The deadline was on March 24th. So those should be available for your review and posted. And then our next regular monthly meeting and hearing will be Friday, April 24th, and that's for EIB 25-32, amending food service and food processing regulations. And Member Bitzer will be the hearing officer for that hearing. You remember that, Member Bitzer? Yeah.
I do.
Oh, you do? Okay.
I have a question related to that for council. I am now myself a certified kitchen manager. Got my little certification right here.
You're a food processor?
Well, I supervise the kitchens here that feed the kids. We have a K through 12, and yeah, they tacked the additional duties on after I got back from Africa. So, so I don't know. Am I conflicted if I'm part of the regulated environment? I guess I could chair it. I guess I could chair it and just recuse myself from voting. I don't know.
I Member Bitzer, could we perhaps talk about that offline?
Sure.
Okay.
But yeah, if we got a green light, then I'm ready to go. But I am, like I said, now a participant in food regulations.
Understood. I'll contact you.
Thank you, sir.
Great. Are there any other items that we need to discuss today before we adjourn? Seeing none, I don't think we have to do a roll call vote. I'm going to call for adjournment. Thank you all for being here. Thank you to the department for your excellent case. And we'll see you on April 13th.